Otherwise, come.
He has come.
Okay, both sides are duly represented. It is submitted that the matter was extensively heard before another bench of this court. Accordingly, the registry shall examine the same and list the matter before appropriate bench. Honorable Mrs. Aziz. Next paragraph.
Yeah,
Who is the officer present? Name, just give me the name.
Name we have given, no? Name in a piece of paper we have given this name and everything.
Mr. So and so.
He's Inspector Tanvir Ahmed.
Directed to whose personal appearance was directed is present. So he shall appear before the court on the next date of listing. List on day after tomorrow. You
Day after tomorrow, my lord. Obliged, my lord.
Yes.
My lord, I am mentioning for a bail matter for motion tomorrow, my lord. Because the reason is this, my lord, it was rejected along with the co-accused, the main accused. He was enlarged by on bail on last Thursday, my lord. So can it come tomorrow, my lord?
May I please, your lordship? I am appearing on behalf of Mr. S.M. Adhabak, my lord, for item number 5. It's out of station, my lord. Matter may be possible for the day, my lord.
Okay. Adjourn for the day is paid for by for the petitioner. Okay.
Daily list item number 1, motion.
May I please, Lordship? Lordship, I beg to mention BA 657 of 2023. The matter was
Yes.
May I please, your lordship? Second time bail application, lordship. Kindly call CD. Last reject order.
Where is the
case number
previous order?
13.
Page 13.
13, lordship.
13.
13. The 11 questions start
1/11,
from page 14.
2022. 5 months. Here over 5 months, lordship. Till today's charge sheet not submitted. Kindly subsequent development CD, lordship.
There would be no change in circumstances, Mr. Aramji.
Lordship. And no new grounds.
Is there any change in circumstances?
Lordship. Other two accused already arrested, all things recovered. From other accused, charge sheet not submitted till today, lordship.
Instead of producing the case diary, Mr. Bhaskar Shabal, the APP, shall obtain the status report of investigation and note of the IU insofar as the petitioner is concerned. When list on?
Any date, Lordship. Next week, Lordship, any date.
Give a date.
Lordship. 28. 27, 28, Lordship.
27th. Okay.
27 this one.
Otherwise, Lordship, no new ground had been urged here, Lordship.
I understand, but let us see, Mr. Alamgir.
2 and 3 for admission.
Mr. Shabat, times we can't be so very technical. Yeah, otherwise, right?
In this case, Lordship, he was also previously wanted in some other case also, Lordship. He didn't get
You get that information also.
Lordship.
all the difficulties. I'm sorry to,
But you'll have hardly anything to argue. Most of your argument has already been
I'm not going to
Made.
repeat, I'm not going to repeat anything, Milord. Whatever my learned friend, my senior friend has argued on the question of interpretation clauses and all those things, I'm not going to argue. Because whatever I noted, all the points he has been,
I was also examining that only.
I only, Milord, would like to place some judgments etc. on the scope of the judicial power, review power in the contractual matters. So, इसी की बंद करो। एक comparison से।
Yes,
My lord, after going through all the judgments which I am placing
only
before
few,
you, my lord,
only few.
my lord, when somebody is arguing for 2 days, somebody argues some, it's my duty also to contribute something, my lord.
Apologies, my lords, but I think the microphone is off. We can't hear him.
It's on.
Don't seem to be able to hear him.
I don't know because then always it happens, my
No,
lord, when
we
the,
have designed this for that only.
my lord, it always happens, my lord, when somebody's case is strong, other side never has. Case is- It's going on only to your lordship, my lord. Well, at the, after going to judgment, I found, my lord,
Taking him up to particular. Not able to listen. Now you're getting voice?
My lords, we can hear you, but the other side, we're not able to hear.
Oh, good.
there.
Can hear now, I think.
Otherwise, also our voice is very loud. So once we start, you will hear without mic also.
So that depends, Dr. Saraf, on two things. Number one, whether the brief is for arguing or for hearing.
But that is always, well, it depends on the, I will not say in the court, my lord, it also depends on many other factors.
Okay.
My lord, after going through the judgments, my lord, I found one thing, my lord, that the scope of judicial review in the contractual matters, so far as the interference with the decision of the employer, is very limited. The court can interfere with the decision of the employer in case prima facie the decision is so arbitrary, so perverse, that no reasonable person could have taken such a decision. Also, my lord, insofar as the decision or interpretation given by the employer to the clauses of the tender document is to be taken to be accepted because he knows that how it has been framed. And even if two interpretations are possible, then also the court will not sit as a court of appeal and will not take a decision at the matter. Now, here I was asking him to myself a question, Milo, whether the interpretation which has been given by the responding corporation, Milo, is so arbitrary or perverse that calling for the interference of a lawsuit. The very fact that to explain the clause, one eligibility criteria clause and all those things, 2 days were taken by the respondents to convince your lordship that itself shows that the decision which has been taken by the respondents is not prima facie arbitrary or perverse. If it would have been prima facie on the looking of the clause itself, it would have arbitrary, then there was no necessity of 2 days for arguing the matter on the basis of clauses. So, my lord, when somebody wants to, my lord, your lordship's interference in the matter, on the basis of an interpretation of a clause, then what is the limit and how far, my lord, your lordship will interfere? On that only, my lord, I would like to, although my learned friend has also placed the last judgment where the apex court has gone to the extent that even if it is malafide, then also you go for the damages. No question of interference by the court. I will place, my lord, some of the judgments. My lord, lordship may see first judgment starts at page 1 and relevant part at page 10. Paragraph 14 below. Yes, you do.
NG projects.
Well, this is not NG project, my lord. This is, my lord, G.J. Fernandez.
Okay.
Volume 1, your lordship, volume 1.
Yes.
Well, can I ask the court master, my lord, to switch on the AC? If it is not inconvenient to your lordship.
The AC is on.
Okay. Because mine is company from Italy. So, my lord, generally the temperature is obviously high, my lord. Well, lordship, say page 10, para 14.
That will only happen if you are arguing with anger.
Not anger, my lord, sometimes it depends on the my lord, for whom you are arguing.
Obviously, for your friend, Mr. Gandhi.
That is always, my lord, one of the factors. There is no doubt about it, my lord. And as my lord, as earlier also I submitted for lordship. On the backside, my lord, Gandhi is laughing. So, my lord, he is looking at us and laughing, my lord.
No. Laughing at my back because they are thinking, why?
My lord, I have to give
Why should I have been here?
I have to give that interpretation only. Well, he says, secondly, whatever may be the interpretation that a court may place on the NIT, the way in which the tender document is issued by it has been understood. Paragraph 14 below.
14.
I'm sorry, page 10.
Yes.
Secondly, whatever may be the interpretation that a court may place on the NIT, the way in which the tender document issued by it has been understood and implemented by the KPC is explained in the note, which sets out the general procedure which the KPC was following in regard to the NIT issued by it from time to time. Para 2 of the note makes it clear that the KPC took the view that para 1 alone incorporated the minimum pre-qualification eligibility conditions, and the data called for under para 5 was in the nature of general requirements. It further clarifies that while tenders will be issued only to those who comply with the pre-qualifying conditions, any deficiency in the general conditions will not disqualify the applicant receiving the tender documents, and the data regarding these requirements would supplied later. Right or wrong, this was the way they have understood the standard stipulation, and on the basis of which it had processed the applications for the context all along. The minutes show that they did not deviate or want to deviate from the established procedure in regard to the context, but on the contrary, decided to adhere to the, even in regard to the context. They only decided in view of the contentions raised in the appellant that para 5 should be not be treated as part of the pre-qualifying conditions, that they would make it specific and clear in their future NITs that only the fulfillment of the pre-qualified conditions would be mandatory. If a party had been consistently and bona fide interpreting the standards prescribed by it in a particular manner, we do not think that this code would interfere, though it may be inclined to read or constitute the conditions differently. We are therefore of the opinion that the High Court was right in declining to interfere. So, my lord, the court may be inclined to read or constitute the conditions differently, but that will not a reason to interfere with the decision taken by the employer with regard to the interpretation of the tender conditions, and subsequent judgment will show that when it can be interfered, the decision taken by when it can be interfered. Next decision, below I will placing before lordship. It starts with page 13 and 11 part at page 34. Para 70 below.
Yes.
It cannot be denied that the principles of judicial review would apply to the exercise of contractual powers by the government bodies in order to prevent arbitrariness or favoritism. However, this must be clearly stated. There are inherent limitations in the exercise of that power of judicial review. Government is one of the guardian of the finances of the state. It is expected to protect the financial interest of the state. The right to refuse the lowest or any other tender is always available to the government. But the principles laid down in Article 14 of the Constitution have to be kept in view while accepting or refusing tender. There will be no question of infringement of Article 14 if the government tries to get the best person or the best quotation. The right to exercise or choose cannot be considered to be an arbitrary power. Of course, if the said power is exercised for a collectoral purpose, the exercise of that power will be struck down. So, my lord, there is no submission that the power was exercised for any collectoral purpose, so as to invite your lordship's interference in the decision-making process, my lord. Your lordship may thereafter come to para 77. At page 36.
Yes.
The duty of the court is to confine itself to the question of legality. Its concern should be whether a decision-making authority exceeded its powers, committed an error of law, committed a breach of rules of natural justice, reached the decision which no reasonable tribunal could have reached, or abused its powers. Therefore, it is not for the court to determine whether a particular policy or a particular decision taken in the fulfillment of the policy is fair. It is only concerned with the manner in which these decisions have been taken. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which the administrative action is taken is subject to control by judicial review can be classified as under illegality. This means the decision maker must understood correctly the law that regulates the decision-making power and must give effect to it. Irrationality, namely reasonableness and procedural impropriety. The above are the broad grounds, but it does not rule out the addition of further grounds in course of time. As a matter of fact, in so and so, law refers specifically to one development, namely the possible recognition of the principle of proportionality. In all these cases, the text to be adopted by the court is the court should consider whether something has gone wrong of a nature and degree which requires intervention. The para 94 at page 44.
Yes.
The principal judicial are from the above are the modern trend points to judicial restraint in administrative action. The court does not sit in as a court of appeal, but merely review the manner in which the decision was made. The court does not have the expertise to correct the administrative decision. If a review of the administrative decision is permitted, it will be substituting its own decision without the necessary expertise, which itself may not be valuable. The terms of the invitation to tender cannot be open to judicial scrutiny because the invitation of tender in the realm of contract. You'll also be note it below. Normally speaking, the decision to accept the tender or award the contract is reached by the process of negotiation through several tiers. More often than not, such decisions are made qualitatively by experts. The government must have the freedom to contract. In other words, a fair play in the joints is the necessary concomitant of the administrative body functioning in an administrative sphere or quasi-judicial sphere. However, the decision must not only be tested by the application of the principle of the reasonableness, but always must be free from so-and-so. Quashing decisions may impose heavy administrative burden on the administration and lead to increased unbudgeted expenditure. Based on these facts, the principles will be there. Okay. Now, also similar page 76 and the relevant part at page 82. Below, para 8 at the bottom below, 9 at the bottom. Even when the state or public authority below. Even when the state or a public body enters into a commercial transactions, consideration which will prevail in a decision to award the contract to a given party would be the same. However, because the state or public body or agency of the state enters into such a contract, there would be in a given case an element of public law or public interest involved in such a commercial transaction. What are these elements in the public interest? Public money would be expended for the purpose of the contract. The goods or service which are being commissioned would be for public purpose, such as construction of road, public building, power plants and utilities. The public will be directly interested in the fulfillment of the contract so that the services become available to the public expenditure. The public would also be interested in the quality of the work undertaken or supplied by the tender. Poor quality of the work can lead to tremendous hardship and the substantial financial outlay either in correcting mistakes or defects or so and so. This I'm placing on the interest of public interest because the court in the subsequent judgments have said that if public interest is there, is affected, the court may interfere. Now we'll also see para 12 at page 83. when a petition is filed in public interest litigation challenging the award of contempt by the state or public body in a particular manner, the court must satisfy that the party which has brought the litigation in so and so bona fide public good. The public interest litigation should not be merely a clock to so and so. You'll also skip over. The court must be careful to weigh the conflicting public interest before intervening. Intervention by the court may ultimately result in delay of the execution of the process. The obvious consequence of such a delay is price escalation. If any retending is prescribed, cost of the project can escalate substantially. What is more important is that ultimately the public will have to pay much higher price in the form of the delay in commissioning of the project, and the consequent delay in the contemplated public service becomes available to the public. If it is shortage in electric supply and the consequent construction of the industrial development, if the project is of the construction of a road or an irrigation canal, the delay in the transportation facility becomes available, or the delay in water supply for agriculture purpose can be substantial setback to the country's economic development, where the decision has been taken bona fide, where the decision has been taken bona fide, and a choice has been exercised on legitimate considerations and not an arbitrary. There is no reason why the court should entertain a petition under Article 226. Now, why the decision was taken to award the contract to the private respondent? The Oil India has given their reasons, speaking orders, that why they have taken the decision. Now, there is no mala fide has been alleged. Now, you'll also have to see whether the decision was taken bona fidely and whether it is not on legitimate consideration and not arbitrary. Hence, before entertaining a petition, passing an interim order, such court must be carefully weigh conflicting public interest. Only when it comes to a conclusion, there is an overwhelming public interest in entertaining the petition, the court should intervene. Now, public interest, that's why I placed before lordship that what is the meaning of the public interest. This is also a oil project, which is an essential service. And I placed before lordship that how much work has been already been done by the fellow respondent after the award of the contract. Now, whether at this stage the lordship will like to interfere in the matter about the eligibility of the respondent to get a contract. Now, your lordship may kindly see me, Lord. Page 88, relevant part 100. Para 22.
Yes.
Judicial review of administrative action is intended to prevent arbitrariness, irrationality, unreasonableness, bias, and mala fide. Its purpose is to check whether choice or decision is made lawfully and not to check whether the choice or decision is sound. When the power of judicial review is invoked in matters relating to tenders or award of contract, certain special features should be borne in mind. A contract is a commercial transaction. Evaluating tenders and awarding the contracts are essentially commercial functions. Principles of equity and natural justice stay at a distance if the decision relating to award of contract is bona fide and in public interest. Courts will not, in exercise of power of judicial review, interfere even if a procedural aberration or error in assessment or prejudice to tender is made out. You'll also kindly note it, madam. The power of judicial review will not be permitted to be invoked to protect private interest at the cost of public interest or to decide contractual disputes. The tenderer or the contractor with grievance can always seek damages in civil court. Attempts by unsuccessful tenderers with imaginary grievances wounded pride and business liability to make mountain out of molehills of certain technically procedural violation of some prejudice to self and persuade the courts by to interfere by exercising power judicial review should be resisted. Such interference, either interim or final, may hold up the public works for years and delay relief and so to to thousands and millions and may increase the project cost manifold. Therefore, a court, before interfering in the tender or contractual matters and exercise the power judicial review, should pose to itself the following questions: whether the process adopted or decision made by the authority is mala fide or intended to favor someone. Now, the first question which has to be posed is whether the decision was mala fide and intended to favor somebody. Now, second, whether the process adopted or decision made is so arbitrary and irrational that the court can say the decision is such that no reasonable authority acting reasonably and in accordance with the relevant law could have reached. And third, whether public interest is affected. If the answers are in negative, there should be no interference in Article 226 cases involving blacklisting or imposition of penal consequences on so on so on. Now, the situations in which the court can interfere, after going through the petition and the arguments, reasons for the which is challenge to the award of the contracted petitioner, I don't find that any of the three conditions are fulfilled. It doesn't say arbitrary, it is so arbitrary that no reasonable person could have taken such a decision. If no reasonable person could have taken such a decision, prima facie on a plain reading of the clause itself, it will be apparent that yes, this goes. If somebody has to, like my lord in the review, if somebody has to put arguments and etc., everything to show that no, this interpretation, this word, that word, then my lord, in my humble submission, it cannot be said that no reasonable person could have taken such a decision. Now we'll also kindly see page 106 and 11th part at 116. Para 27 below.
Yes.
The bidders participating in the tender process have no other right except the right of equality and fair treatment in the matter of evaluation of the complete bids offered by the interested persons in response to the notice inviting tenders in a transparent manner and free from hidden agenda. One cannot challenge the terms and conditions of the tender except in the above state ground. The reason being terms and invitation of tender are in the realm of the contract. No bidder is entitled to, as a matter of right, to insist on the authority inviting tender to enter into further negotiation of the terms and conditions of notice provided for such negotiations. So, my lord, I was asking question myself whether in this case the employer has in any manner acted in such a manner that is not interfering with the right to equality or the fair treatment to the petitioner. The Lordship will be aware, my lord, the Lordship will not, in the judicial review, is only examining the decision-making process, not the ultimate decision which has been taken. Now, whether Lordship will find that in this present case, the decision-making process is so arbitrary or perverse or suffers from such an infirmity that calls for interference by your Lordship. Your Lordship will find that the decision was taken by the employer in a fair manner by giving all the reasons. Now, the ultimate decision which was taken by the employer, in my humble submission, that cannot be subject matter of challenge in Article 226, and your Lordship will not sit as an appellate court to examine the final decision which was taken by the employer. Now, your Lordship may kindly see page 143. And relevant part as page 153. Paragraph 32.
Yes.
You may, while parting, point out that out of the total of so-and-so crores representing the estimated value of the contract, respondent number 2 is certified to have already executed work worth rupees so-and-so crores and received the sum of rupees so-and-so towards the said work. More importantly, the work is question relates to drinking water supply scheme for the respondents of a society district municipality. The project is sponsored with the central government assistance under the urban infrastructure scheme and small and medium towns. The completion target of the scheme is September 2012. Any interference with the award of the contract at this stage is bound to delay the execution of the work and put the inhabitants of the municipal area to further hardship. Interference with the ongoing work is therefore not conducive to public interest, which can be served only if the scheme is completed as expeditiously as possible, giving relief to the thirsty so-and-so. This is particularly so when the elements also. So, my lord, the ongoing project, and I place before Lordship that after the work was allotted to the petitioner, the respondent, private respondent, my lord,
Yes.
what steps have been taken? In fact, in respect to 2 rigs, the completion target is in this year itself by October 2023. And the petition, the private respondent has already placed orders with everything while making huge payment. And out of that irrecoverable amount, in case I cancel it, the amount which will not be paid, I've given an affidavit before Lordship, I place it before Lordship. Lordship may see page 168 and 11 part at 174. Para 13.
Your affidavit in opposition.
Well, the additional affidavit is filed, right? It was filed on 18/2/2023. Lord. Yes, for the timing, sorry. One zero 1012, my lord, page number 1012, running page. 1012.
Yes,
My lord, in this case, affidavit, you'll also may see, I've given a chart. You'll also find 1016.
yes.
This is the description of the work. And Lord may see amount in million USD that has already been paid. And on the next column, irrevocable amount in $1 million, that this amount, in case the order is cancelled, my lord, then this amount will not be recovered. And the remarks, what is the stage of the work,
Okay. There's no difficulty because this father and son,
my lord?
it's a transaction between father and son.
Because always nowadays, the father and son, income tax also, my lord, the father and son are treated differently. Question was that, my lord, that what steps have been taken by the private respondent, what stage the work is there. Now, at this stage, any interference with the contract which has been granted to the private respondent will not be in public interest, because 2 rigs are to be completed in October 2023 itself. In respect of others, the orders have already been placed. Huge amount has already been paid. And even if you'll also see the irrecoverable amount, that also 23 million US.
Yes,
Yesterday, when I was reading, my lord, I forgot the dollars. So either 23 million means 2 crore something. But ultimately, I was told that no, don't read it in Indian rupees, it in US dollars. I will also see page 174. Paragraph 13, my lord. In other words, a mere disagreement with the decision-making process or the decision of the administrative authority is no reason for a custodial court to interfere. The threshold of malafidis, intention to favor someone, or arbitrariness, or irrationality, or perversity must be made before the custodial court interferes with the decision-making process or the decision. para 15 million, we may add that the owner or employer of the project having authored the tender documents is the best person to understand and appreciate its requirements and interpret its document. The custodial courts must defer to this understanding and appreciation of the tender documents unless there is mala fide or perversity. You will also kindly note it below. That the understanding of the employer of to the tender conditions can be interfered with only when there is mala fide or perversity. In the understanding or appreciation or in the application of the terms of the tender condition, it is possible that the owner or employer of a project may give an interpretation to the tender documents that is not acceptable to the custodial courts, but that by itself is not a reason for interfering with the interpretation given. So, my lord, even if by way of argument, your lordship comes to conclusion that yes, some other conclusion could have been reached, but that is not a reason in my humble submission on the basis of the decision of the apex court to interfere with the decision so taken. Now we'll also kindly come to page 234. And relevant part at 244. Para 20.
234,
Well, it starts at 234,
relevant page.
244. Para 20 below. The essence of the law laid down in the judgments referred to above is the exercise of restraint and caution. The need for overwhelming public interest to justify judicial intervention in matters of contract involving state instrumentality, the court should give way to the opinion of the experts unless the decision is totally arbitrary or unreasonable. The court does not sit like a court of appeal over the appropriate authority. The court must realize that the authority floating the tender is the best judge of the requirements, and therefore the court interference should be minimal. The authority which float the contract or tender has authored the tender documents is the best judge as to how the documents have to be interpreted. If two interpretations are possible, then the interpretation of the author must be accepted. The courts will only interfere to prevent arbitrariness, irrationality, bias, mala fide, or perversity. With this approach, we shall now deal with the present case. So, my lord, the apex will say, my lord, that even if two interpretations are possible, then also the decision which has been taken by the employer, that should be accepted. Now we take a lordship to my lord. Page 265.
This is already cited by Mr. Sen. Monte Carlo.
Sena cited. Again, my lord, I may reiterate for my satisfaction. Para 29, page 302.
Para,
29, my lord, page 302. Thus, from the aforesaid decision, it can be, you know, seen that the court before interfering,
this is repetitive because it is referring to this.
my lord,
Tata Sundar and
my lord, Your Worship.
Jagdish Mandal.
Again, Your Worship, see para 36 also, Your Worship may note it, my lord,
Para,
36.
36.
Will not paste that one, Your Worship, I've already seen it. Your Worship may see page 310. Reflex space position again. 310, the relevant part at page 317. Para 2, my lord.
Yes.
The judicial review of such contextual matters has its own limitations. It is in this context judicial review of the administrative actions that this court has opined that it intended to prevent arbitrariness, intentionality, unreasonableness, bias, or malafide. The purpose is to check whether the choice of decision is made lawfully and not to check whether the choice of the decision is sound. In evaluating tenders and awarding contracts, the party are to be governed by the principles of commercial prudence. To that extent, the principles of equity, natural justice have to stay at a distance. We cannot lose sight of the fact that the tenderer or contractor with the grievance can always seek damages in the civil court, and thus attempts by unsuccessful tenders with imaginary grievances, wound pride, business liability to make mountains out of the molehills of so-and-so, and persuade the court to interfere in exercising judicial review should be resisted. In a sense, additional principle imported in the concept that the decision is so arbitrary or irrational that it can never be that any reasonable authority acting reasonably and in accordance with law would have reached to such a decision. One other aspect which will always be kept in mind is that the public interest is not affected in the prospectus of so-and-so. You'll also see B, D, C mirror. In the matter of formulating conditions of a tender documents and awarding a contract matter, greater latitude is required to be considered so-and-so authority unless the action of tendering authority is found to be malicious and a misuse of state power, interference of court is not warranted. Certain preconditions for qualification of the tender have to be laid down in the ensure that the contractor has the capacity and the resources to successfully execute the work, and if the state or instrumentalities act reasonably, fairly, and in public interest in awarding contract, here again interference by court is very restrictive since no person can claim fundamental right to carry on the business with the government. So ultimately, Milo, you'll also have to see whether the decision was malafide was there, whether it was malicious, whether the action was to favor someone, and whether it was so arbitrary a purpose that no reasonable person could have come to the conclusion. And third, lastly, my lord, that whether if the two interpretations are also possible, then also the court should give way to the decision of the employer. Now we'll also again see the decision at page 336.
Since it has come for the third time, I'm just asking you a question. You see, here again, for the third time, it is reiterated that one can always approach the civil court for damages. Can you give me an idea? How would somebody approach the civil court?
That I will ask the Supreme Court, because the Supreme Court says that you can approach, and the other decision says that even if malafide is there, you claim damages. Now, how they will claim the damages, how they will not claim the damages, is up to the person who is going to claim the damages on the basis of Supreme Court decision.
Okay.
We are bound by the Supreme Court decision. Supreme Court is saying that do it. There must be some way then. Lord, at page 342, para 20. This is a 2022 decisions below. Well, many times, with due respect, the decisions of the Appellate Court, when we read it, my lord, we go by the line that what is there and what is not there, because they are the Supreme, my lord. When we say they must have thought of some means. Para 20, my lord, at page 342.
Yes.
The scope of judicial review in the matters of tender public action has been explored in depth by this court in category of decisions. Plausible decisions need not be overturned, and at the same time, latitude ought to be granted to the state exercising its executive power. However, allegation of illegality, irrationality, and procedural propriety would be enough grounds for the court to assume jurisdiction and remedy the so and so. Thereafter, also you see page 343 at para 22. The exposition of the law on the subject has been consistently followed by the court, even in the later decisions holding that superior courts should not interfere in the matters of tenders unless substantial public interest was involved or the transaction was mala fide. Now, again, it has been further restricted, my lord, that the court should not interfere unless until substantial the public interest is involved and the transaction was mala fide. Now, my lord, so far as public interest is concerned, I think public interest is in my favor. The question of mala fide has not been alleged at all. And thereafter, further, Lord see, it was consistently stressed by the court that the needs of the overwhelming public interest should always be kept in mind to justify judicial intervention in contexts involving the state and its instrumentalities. And while exercising the powers judicial review in relation to the contract, the court should consider primarily the question whether there has been any infirmity in the decision-making process.
Yes.
25 million. The law on the subject is settled that the courts being the custodian or fundamental rights are under an obligation to interfere when there is arbitrariness, unreasonableness, mala fide or bias, if any. But at the same time, the court should exercise the power of judicial review with a lot of restraint, particularly in contractual and commercial matters. Philosophy, volume 2, Milord. Philosophy starts with 346. Philosophy mechanics, para 22 at page 363.
Just a question before you start with this.
Hello.
You see, why public interest angle cannot be explored with a view that if for any reason the petitioner succeeds, then your first statement that amount being paid in US dollars, that would remain in the country, number one. Second is that it is the company of national importance, which will be doing the work, which will be again in greater public interest of the country.
I don't think so, my lord, in the present scenario. The question of the company of the India doing the work, the money remains here. These are not the considerations. This is the Indian company, my lord, Mecca Engineering, in the Hyderabad-based company. Secondly, the US dollars and all those things, the amount which is will not be recovered. I place the orders. Now, as I submitted, 2 weeks, the project will be completed in October 2023. Others are in the process, and a substantial work has already been done. Now, whether it will be in public interest to interfere at this stage, whether there is an allegation of malafide, whether the decision was taken to favor the respondent, private respondent, and whether lawsuit finds that the decision was so arbitrary or unreasonable that prima facie reading with the clause, one can come to the conclusion that no, the private respondent was not entitled, but he was given. These are the questions which a lawsuit will pose. And if a lawsuit comes to the conclusion, yes, such a without unreasonableness, perversity on a plain reading of the clause itself is there, then the lawsuit as in the review when we say error apparent on the face of the record, where it has been said that when the debating and debates and all those things are necessary, then it is not an error apparent on the face of the records. Repeating again, my lord, if so much time was necessary to convince your lordship that this is the interpretation of the clause, in my humble submission, that itself indicates that there is no perversity or unreasonableness, and the decision which was taken, as your lordship may ultimately, after hearing all the technicalities of the words, commas, full stops, may come to the conclusion that this decision, there is another view, is possible. But that is not a ground for interfering in the contractual matters. A case may be there where prima facie by reading of the clause itself, you have come to clauses, one shows that no, this is prima facie arbitrary illegal. If one has to go to the definition of statutory company, if you also wish to look into the definition of this, that, what is the meaning, both sides are arguing the matter and all those things, trying to convince your lordship that this is the interpretation of this clause. In my humble submission, that cannot be a reason for interference with the contractual matters. Lordship may see page 363. Otherwise, my lord, in contractual matters, all the matters, in all matters, my lord, this view or that view may be there. By arguing, my lord, and all these things, my lord, contractor, who, my lord, the employer who gives the work, he is not a legal expert in that field. My lord, when the decisions are taken, when, my lord, the lawyers come to the lawyers, we look into the magnifying glass, the decisions taken and the clauses, and examine, my lord, whether this was so and that was so. That's why I think the courts have said that it should be prima facie so absurd and so irrational or so, my lord, perverse, the court may interfere, but otherwise no. Para 20, my lord, 22 at page 363.
Yes.
The satisfaction whether a bidder satisfies the tender condition is primarily upon the authority inviting the tenders. Such authority is aware of the expectation from the tenders while evaluating and consequences of the performance. If the tender in question, there were 15 bidders, bids of 13 bidders were found to be unresponsive, that is not satisfying the tender conditions. The writ petition was one of them. It is not the case of the writ petitioner that the External Tendering Evaluation Committee was actuated by extraneous considerations or was bona fide. Therefore, on the same set of facts, different conclusions can be arrived at in the bona fide manner by the Technical Evaluation Committee. Since the view of the Technical Evaluation Committee was not being liking of the writ petition, such decision does not warrant for interference in the grant of contract to a successful contract. In view of the above, the judgments of the court, the writ petition court should refrain from imposing its decision over the decision of the employer as to whether or not to accept the bid of the tender. The court does not have the expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Courts should be more reluctant in interfering in the contractual involvement's technical issues, as there is a requirement of necessary expertise or adjudication upon such issue. The approach of the court should not be to find fault with the magnifying glass in their hands. Rather, the court should examine as to whether the decision-making process is after complying with the procedure contemplated by the tender conditions. If the court finds there is total arbitrariness, but the tender has been granted in a mala fide manner, still the court should refrain from interfering in the grant of a tender, but instead relegate the parties to seek damages for the wrongful exclusion rather than to injure the execution of the contract. Now, my lord, here the court goes to the extent that even if the court finds that the total arbitrariness or the tender has been granted in mala fide manner, then also the court should abstain from interfering in the grant of the tenders. The parties should be relegated to the claim for damages. The injunction or interference in the tender leads to additional cost of the state and is against public interest. Therefore, the state and its citizens suffer twice. Firstly, by paying escalation cost, and secondly, by being deprived of the infrastructure for which the process within the government are expected to work.
Yes.
Well, next, you'll also see page 365. And 11 part at page 382. Para 24, Lord. The scope of judicial review in contractual matters, and particularly in relation to the process of interpretation of the tender documents, has been subject matter of discussion in various decisions of this court. We did not multiply the authorities on the subject, as suffice would be to refer to the 3-judgment judgment of this court in Galaxy Transport, wherein, among others, the said decision in EPCON India has been considered, and this court has disapproved the interference by the High Court in the interpretation of the tender inviting authority of the eligibility term relating to the category of the vehicles required to be held to the bidders in the tenders allotted to for the supply of vehicles for the category of troops and the equipment. Thereafter, my lord, the decisions have been referred to, my lord. And Lordship is keeper, para 26 at page 387.
I think this was cited by Mr. Sen. Agmatal.
Yes.
At 26 at page 387, the above mentioned statement of law makes it amply clear that the author of the tender document is taken to be the best person to understand and appreciate requirements, and interpretation is manifestly.
This I have already noted.
My lord, my lord. Galaxy also you have cited.
No, Galaxy is not cited.
Page 397 below. Para 14,402. So same law has been reiterated, my lord. I'm placing this judgment only to show, my lord, that this, the interpretation which was given earlier, my lord, that is consistently followed by the apex court, para 13, my lord, para 14, page 402. And in fact, the recent trend is that the apex court has further objected no, because earlier, my lord, it was said arbitrary, irrationality, and all those things. And perhaps that was very wide a term to say that whether arbitrary, irrationality. So, my lord, subsequently, my lord, they added the word so arbitrary. Earlier it was arbitrary, now so arbitrary. And subsequently they say, even then the the courts were interfering. So they have to come up and say that even if mala fide and irrational, then also you should not do. Although that will be dangerous proposition for me also, because I may also come sometimes on behalf of the petitioner to challenge that. But what can be done, my lord, we'll find out some ways and means. Or, my lord, the Supreme Court nowadays, my lord, as it was correctly said, that Supreme Court judgments are now railway tickets valid for one journey only. So perhaps nobody knows tomorrow, day after tomorrow, something new may come. But till today, the ticket is valid, my lord, for me, for the journey which I am undertaking. My lord, at page 424, the judgment starts at page 408. I will take your lordship to page 424.
Because now this is a statement will only Mr. Sen would be able to examine.
Lord, the same.
He's usually from there.
Lord,
So now
Mr. Chain may not say.
Now this whether the statement of railway ticket
Well, I will say how it is
contentious or not.
I
That
will
is
say,
only for him to see.
I will say how it is applicable. I filed a writ petition earlier. When the 46th amendment, the decision of the photographic works, the rainbow decision was there. That came in my favor. Then another decision came, which said that we doubt the decision of the rainbow. Then another decision said no, doubting itself is not sufficient. That judgment prevails. Then came BSNL. We said, no, all these two judgments are wrong. Rainbow is reversed. Now, some cases, I got disposed of after the rainbow. Unfortunately, one case was left out. And in the meantime, the BSNL judgment came. That was decided against the party. So, the railway ticket of earlier was valid. Second, when purchased the new ticket, that was, the journey was not there. And your lordship has always seen the promissory estoppel. Since starting from I have not been able to understand what is promissory estoppel. Although my lords in the Supreme Court are understanding, it is difficult for the lawyers to understand what is promissory estoppel.
One of the early judgment was authored in this court only on promissory estoppel, much before that theory was expounded in the Supreme Court. This and Wednesbury unreasonableness. Our judgments are prior in point of time. The theories are there. The theories are there from the what you call Hasbury laws, but the expounding of the theories are in these two aspects are.
Recently the VVF judgment by Justice Gawai, I think. If your lordship reached that judgment, and lordship, my lord, the earlier judgments, all judgments, have to go. Prior to that,
We won't comment there, but yes, there are two or three theories which this court is the.
now it become very difficult because the Supreme Court has said per incurium, so far as the High Court is not to say the per incurium and all those things. Now the apex Supreme High Courts may not have to follow the last judgment because they refer some judgments also one line here and there.
No, those theory, if something arises, I'll explain, but.
That will be outside the court, my lord, we can discuss, but it will not be better.
It's a settled theory how per incurium and that can be found out.
Per incurium. Per incurium. The Supreme Court has said that High Court has no right to say that there were judgments of per incurium. I will give you judgment to us. The my lords can only say per incurium. The High Court has no right to say the per incurium. I will give you lordship.
In fact, there's an interesting recent, I just read it in bar and bench, like just a cursory reading. Apparently, whether a judgment, suppose a judgment is overturned, then any other decision given on the basis of that judgment
that is
can be reviewed.
That is referred to larger bench now.
That will be referred to a larger bench because there's a between the Supreme Court, I think Justice Shah and Justice Nagara.
No, because the theory is that those judgments are saved.
Yeah. No, but now there is split now saying that if one, I think one view which has been taken is it can be reviewed, and therefore it has now gone to a larger bench for decision.
My lord, one of the cases, my lord, subsequently, my lord, the judgment was held to per incurium.
Per incurium, read the judgment of the Bombay High Court full bench.
These are very,
It refers to two constitutional bench judgments of the Supreme Court, and then it decides the matter.
these are very risky terms.
No, I don't know, but
It's a Bombay High Court.
full bench.
Full bench.
But normally, my lord, the apex court, I got one decision, my lord, where they say that no, it's not the High Court to say that per incurium or not.
You see that judgment?
I think
it was very
because
useful reading.
they say that it is for the lordship to say, my lord sitting in the Supreme Court per incurium or not, High Court not so say.
Given that citation,
I will satisfy. So these are the my lord Bibles. We keep it ourselves with us with always armed with it, my lord. Well, lordship, see page 424, my lord. 8 or 9 lines from of para 26, my lord.
402.
402, 424, my lord, this conclusion.
Yes.
8 or 9 lines from bottom of para 26, my lord. Exercise of power.
Yes.
Exercise of power of judicial review would be called for if the approach is arbitrary or mala fide or procedure adopted is one to favor one. The decision-making process should clearly show that the said maladies are kept at bay, but where a decision is taken that is manifestly in consonance with the language of the tender document or subjects the purpose for which the tender is floated, the court should follow the principle of restraint. Technical evaluation or comparison by the court would be impermissible. The principle that is applied to scan and understand the ordinary instrument relatable to contract in other spheres has to be treated differently than interpreting and appreciating the tender documents relating to technical work and projects requiring special skills. The owner should be allowed to carry out the purpose, and there has to be allowance for the free join with the actions.
Yes.
Further, my lord, that there are 5 of my affidavit which I placed, my lord, page 1014. I have stated, my lord, that 75% of the engineering work has already been completed.
Yes.
So, my lord, in my humble submission, the decision taken by the Orient Limited to award the contract to me, at least from my side, I can say, my lord, that cannot be said by any stretch of imagination to be so absurd, so unreasonable, or so perverse that no reasonable person could have taken such a view, and no malafide and malicious intention being attributed in taking the decision. Applying the law laid down consistently from the very beginning, and subsequently the more restrictive or judgment which has been passed by the apex court. In my humble submission, my lord, the petitioners have not made out any case for interference with the decision taken by the employer to award the contract to the private respondent, that to me, and thereby the writ petition which has been filed challenging the said decision is liable to be dismissed.
Yes.
I'm not repeating the points, my lord, which Mr. Sen has already argued in a very short time and in a very clear, ambiguous manner. He has explained everything so far as the interpretation of the clauses and to show the bona fide of the employer, that is All India, while taking the decision. And once the employer has acted bona fidely, and the interpretation which has been given by the employer is one of the, if I say, my lord, although I say that, this is the only interpretation, but a reasonable and possible interpretation, then, my lord, in my humble submission, no case is made out for interference with the decision taken by the employer. I'm grateful to you, lordship, for giving me opportunity to argue the case.
My lord, yeah, just take 1 minute. My lord, then ask a question about that public interest and foreign aspect. Just to answer that, my lord, just 1 minute. My lord, kindly see.
Please come this side.
Yes, 1 minute.
Please come.
I'm so sorry. My lords, in that, am I audible, my lords?
Yes, yes.
Yes, my lords, in my list of dates which I had given, serial number 3, my lords may note that this is a policy of purchase preference linked to local content. So the party which has 51% local content is preferred. And that's how, my lords, as far as this party is concerned, there's 51% local content more than BHEL. That is the first point, my lords. In fact, BHEL has less local content involved and investment involved. So that's the first point. It's not as if BHEL being a public sector is going to be doing everything in it. That is one part. Second, my lords, as I had pointed out already, the purpose of the tender is to widen participation. My lords, nowadays, the whole scenario has changed. Competition Act has come into existence. People realize the importance of competition. So there is this question of widening participation, which is why, my lords, we are looking at not just public sectors, we are looking at all sectors to participate. So that is the second point. And third point is, my lords, that if we see page 3 of our affidavit in opposition, page 3, my lords, this is very important. And I just wanted to point that out because in the context of harm, public interest, etc. My lords, may see page 3 of the affidavit in opposition filed by OIL.
Whose affidavit?
OIL. That is respondent number 1. Respondent number 1's affidavit. Page 3, para 5. Page 2, para 5, sir. Running page here. Not there, sir.
Yes.
My lords, I'll just read out that para, it's important, my lords. It says the deponent begs to state that the answering respondent company being predominantly engaged in the business of exploration, production and transportation of hydrocarbons has to procure a myriad of goods, equipment as well as services to extract such hydrocarbons. For the purpose of exploration and production of hydrocarbon, drilling is the basic and primary activity which is being done through drilling rigs of different capacity. Pursuant to the same, the answering respondent company took the strategic initiative for replacement of its existing 7 numbers of BHEL make so-and-so in a phased manner, which were commissioned during the years 1984 to 1989. Consequently, tender number so-and-so was initially floated, which could not be finalized since none of the offers received against the tender was found to be techno-commercially acceptable. It is imperative to mention that the existing rigs have completed its lifespan, and as such, these rigs have become vulnerable to safety risk. My lord, this is what I point out. Now, my lords may see their answer in response to this paragraph. Page 876. 75. Page 875 at para 29. My lords, is their response to it.
Para 29.
Para 29.
Yes.
The contents of para 5 of the affidavit in opposition do not require a response. My lord, that's the first statement. It is, however, denied that tender number so-and-so could not be finalized since none of the tenders received against the said tender was found to be techno-commercially acceptable. Respondent number has failed to place any record. So, my lord, they do not deny this. They are also experts on this area. It's not that their rig also. Of course, it is their rig, and they are experts. So they do not deny the aspect about safety. I know. I've said that. My lord, it is their rig which is there right now. They do not deny this aspect of safety for this reason. I'm sure they understand that there is a safety risk. Now, every time we react to a catastrophe takes place, we react to it. My lord, we have to take steps in advance. So there is a time bound. There is a certain reason why this should be completed expeditiously, and this safety risk, which is not, it is admitted. Now, the argument will be in a writ, you don't have to follow the rules of pleadings, etc. But my lord, there are certain basic facts. If they are not denied, my lord, that has to be taken into consideration. And my lords, finally, the important point to be kept in mind is, my lords, 2 PSUs fighting with each other. My lord, that's where the public interest actually suffers. So many times Supreme Court has passed, my lords may know that ONGC judgments and all that. Why are public sectors fighting with each other? There are times when it should be given up and unnecessary litigation should not be followed. That's my answer.
May it please your lordship. My lord, the other sides are relying heavily on the judgments of the Supreme Court, where the Honorable Supreme Court has, my lord, in rather, my lord, brought in some self-imposed limitations in certain situations. My lord, I don't know, my lord, I don't think for that proposition, we need to go all these latest judgments, my lord. If we go by the judgment of the Honorable Supreme Court in, my lord, that at 90s of early 90s judgment, where Honorable Supreme Court has way back 30 years back said, my lord, some leeway should always be given to the government when it comes to, my lord, selecting a tender. And more so when, my lord, their technical issues are involved, because court is not supposed to be an expert. Therefore, my lord, now it has been paraphrased in a different manner, saying the employer's choice should be respected. If employer gives a particular interpretation to a particular case, then Justice Madan Lakur has said in that judgment of, my lord, CCL, that court should give due deference. Over a period of time, my lord, the legal principles have evolved. Now, here is a case, my lord. My only humble submission before Lordship is, a decision is an authority for what it actually decides. And every observation without any, formulation of any point, without any argument, without considering the legal, surrounding, my lord, it's not a judgment in rem. My lord, let my learned friends show from both sides. They have cited at least 10, 15, 12 judgments that in any of this case, the concept of this banning had intervened when it comes to taking the expertise of a, my lord, subsidiary. Are we confronted with a single case from the judgment cited by the other side, where the Honorable Court, be it High Court or the Honorable Supreme Court, my lord, was called upon to decide that whether a banned entity which is a subsidiary of a parent holding company, whether his experience can be taken note of? None. That's why, my lord, the Honorable Supreme Court, in this judgment, my lord, very categorically said what should be the law when it comes to accepting a judgment as a precedent. Jagadish Mandal, Cochin International Airport Authority, these are all judgments we have read. Well, I'll just give two judgments, my lord. First is AIR 1968 Supreme Court 647. I'm just indicating, my lord. Paragraph 12. My lord, AIR 1968 Supreme Court 647. The famous case of State of Odisha versus Sudhanshu Shekhar Misra. What the Supreme Court said, my lord, in paragraph 12, which is the longest paragraph, I'll hand over the copy, my lord. A decision is only an authority for what it actually decides. What is of essence in a decision is the ratio and not every observation found therein, nor what logically follows from the various observations made. My lord, the judgments which have been relied upon by the All India or by the private party, my lord, regarding whether, my lord, the credential of a subsidiary which ban can be taken, was it under consideration? That is precisely the case here. Now, my lord, our argument is twofold. As far as, my lord, by the 2017 policy guideline, under which they claim to be governed, then, my lord, the moment they take the credential of Drillmake SPA Italy, they are out. And the moment, my lord, Lordship accepts our argument that in this case 211/21 guideline issued by the ministry will operate, then, my lord, even MEIL is also banned, then it will be an allied firm. I'll come to that, my lord.
Let's just take a break and come back.
Yes, yes. My lord.
যদি এটা আমি করে দিই, এটা আমি কেস করব না
1971, 1 SSC page.
85, my lord.
Yes.
Now it reads as follows, my lord. The court was not called upon to decide and did not decide Article 366(22) was a provision relating to a covenant with the meaning of Article 363. Now this is very important. It is difficult to regard a word or a clause occurring in a judgment of this court diverse from its context as containing a full exposition of law on a question when the question did not fall to be answered in the judgment.
That was paragraph.
My lord, 141. I'm reading it once again, my lord. It is difficult to read a word or a clause occurring in a judgment of this court divorced from its context as containing a full exposition of law on a question when the question did not fall to be answered in the judgment. My lord, yes, in the two judgments cited by my learned friend Mr. Sen, my lord, where it says that whether it is a government entity or a private entity, if it is a subsidiary, it can be construed as a single entity. And therefore, the experience of one can be taken note of. My lord, the facts like the present case never occurred there. Here, the credential, you are using the credential of an entity which is a banned entity. Of course, you are trying to make a distinction between holiday and ban, which does not exist as per the policy itself. Their policy itself, I'll show my ban. So therefore, my lord, some observation made in some judgment on, I would rather say, my lord, the only proposition which can be called out from all the judgments cited by my learned friend Mr. Sen are those judgments that modern trend towards judicial review is restricted. That I can appreciate. Nothing beyond that, my lord. Now, if there is a violation of Article 14, what happens? If an ineligible party is sought to be, given a undue benefit, then it's violation of Article 14, my lord, because you are treating unequal as equal. So where is the question of court, staying away or court adopting a judicial hands-off policy? If there is a wrong, that needs to be remedied. If there is a right, that needs to be enforced. That's also equally important judicial dicta, my lord. If there is a wrong, that has to be, my lord, remedied. And if there is a right, that needs to be enforced. There can be no two opinion about it.
That is the introduction in Specific Relief Act.
Yes, my lord. Now let us deal with the points which has been raised by my learned friend Mr. Sen. My lord, first he says there is no allegation of collusion, malafide or bias. This is not correct. We have made statement. Secondly, my lord, my learned friend is trying to perhaps develop an argument based on malice in fact. My lord, there is a distinction between malice in law and malice in fact. All that we are arguing is malice in law, not malice in fact. My lord, we can also say, here in this case, my lord, the chairman of the Oil India, he retired on 28th, my lord, and he, one second. My lord, this LOA was issued on 28/6/22, and he retired on 36/22. So lot many things can be said on this, but we have not brought this on record because we can't prove it. The fact of the matter is, the chairman of the Oil India issued Oil issued the LOA on 28/6/22, and he retired 2 days thereafter. So, my lord, many things can be said. Anyway, we are not, that's why we brought it. So, therefore, my lord, there is nothing like, my lord, that in every case to bring home the point of malafide, my lord, or an arbitrary exercise of power, we have to name somebody, make some scatting remark against the official. That's not necessary. If from the facts we can demonstrate that these are the tender conditions, this is how they have deviated, therefore they have violated Article 14, that's the end of the matter, my lord. We need not go beyond that. Otherwise, it will be, my lord, entering in a personal, arena, hitting somebody below the belt. That is not in good taste either. So, my lord, I'll just indicate, my lord, our averments regarding malafide, lordship may kindly take note, my lord.
No, because this is something which will also affect me. Because even I propose that till the day I work last,
yes,
I would be working.
Yes. Supposing lordship delivers a judgment on the penultimate day, does it mean yes, certainly? But my lord, the circumstances are such, my lord, sometimes we are compelled to say anyway. That's not my written case, my lord. So, my lord, our averment is ground Z, page 46. then ground double A, double capital A, double C, and double
Just a
D,
moment, ground Z, then,
ground Z, Z for zebra, my lord.
yes,
Then double A, double C, and double D, and all are at page 46, 47, and 48. And double F, double E, double F on my lord, 46, 47, and 48. So we have clearly brought out the elementary my lord pleadings which are required in a case of this nature. Then my lord, the second point which was urged by my learned friend my lord was that the oil's action is legitimate.
just a moment, this
Yes, ma'am.
ground Z, A, C, C, D, D, E, and F, F,
No, Z, comma, double A, comma,
C, C, D, D,
C, C,
E,
D,
and
D,
F, F.
E, and F, F.
F, F, this is for that malice in fact.
Malice in law. We
Malice
say
law,
malice in
okay.
law. We say, my lord, it includes everything, my lord, that there was an arbitrary exercise of power, that it was not done with a good intention, discrimination, everything, my lord. That's the elementary requirement.
Yes,
Then, my lord, the second point which was urged by my learned friend was, my lord, there is bona fide in oil's action because they have taken opinion from 3 legal experts. First, my lord, a senior advocate of this honorable court who is no longer there, my lord. Second, my lord, the oil's legal team. And third, my lord, the Solicitor General's, view. My lord, oil's legal team clearly said it can't be done. They can't say, therefore, their action is bona fide. Oil's team said, we cannot. That is at my lord, page number. Legal team. Page 99 of the affidavit filed by oil, my lord. Page 99 of the oil's affidavit. Para 5.13. In the Solicitor General's opinion, my lord, this
Just a moment.
particular is quoted.
just a moment, page.
Page 99 of affidavit in opposition of oil. That is a sub-para where the oil's opinion is quoted, my lord. Page 99.
That is 5.13.
Yes, if your lordship will kindly come to the sub-para, the quoted portion, my lord, that's the view of the oil team. However, MEL cannot supply item and or rig packages from the Drillmec SPA Italy during subsistence of the order of the department, whereby Drillmec SPA is debarred from carrying out any business with oil, but MEL is at liberty to supply tendered item from MEL USA. So, my lord, their legal team itself said it cannot be. And my lord, regarding the Solicitor General's opinion, I have already read out the other day, my lord. In fact, Solicitor General opined that if you do this, BHL will come up before this honorable court and we are before your lordships. Therefore, to say, to plead bona fide, my lord, it's too much. Then, my lord, third is tender conditions needs to be interpreted in a manner that it will further competition. My lord, that issue itself is begging an answer. For the simple reason, if you give a very strict meaning to this proposition, then you will be violating Article 14. Then you will be treating unequal as equal. So it is antithesis, my lord. This proposition, my lord, is itself begging an answer. That means in the name of competition, encouraging competition, then why do you have these eligibility criteria? If you have an eligibility criteria, then also have a power of relaxation. Now, Supreme Court has said The moment you relax the criteria in favor of one, which will have the effect of unsettling the balance in the tender, then it is bad. My lord, the earlier judgments of the Supreme Court on the contrary said, even in my lord, state of West Bengal State Electricity Board versus Patel Engineering, 2001 to SCC Supreme Court at para 24 said, my lord, the best way to ensure transparency is follow the tender conditions. And that's a very correct proposition in my humble submission, my lord. Yes. That means you are not showing any favor or disfavor. Yes, my lord. If you do something bona fide and in the process there is some shortcomings, then those can be ignored. But those, actions which has the effect of violating Article 14, my lord, that in my humble submission, that cannot be condoned. That power an employer does not have. No judgment of the Supreme Court has ever said that, and neither will say, my lord. Now, interestingly, what had happened in this case, my lord?
Just a moment.
Yes.
What is it judgment you cited?
My lord.
What is it judgment you cited?
My lord, that is 2001. I'm giving, my lord. My lord, my judgment is 2001 to SCC 451 para 24. I'll hand over the copies, my lord. I'll not take your lordship's time by reading the judgments. I'll just make my submissions. Now, in this case, what had happened, lordship will see. Now, how dangerous this proposition will be, I'm just demonstrating it just now. Please come to my lord, the eligibility criteria at page number 100. Yes, please come to 101, my lord. For a moment.
Of the repetition.
Yes.
Please give the page again.
101, my lord.
Yes.
Kindly see, my lord, A.1.2, the first subpara. The bidder should be a manufacturer of OEM. What is OEM? Of mass, substructure, and crown block assembly, or bidder should be a manufacturer of three major components. Am I clear, my lord?
Yes.
Here, my lord, either the bidder should be a manufacturer of OEM, that is mass, substructure, and crown block assembly, or bidder should be a manufacturer of three major components, that is drawwork, top drive, and drilling control system. Am I clear, my lord?
Yes.
Yes. Now come to the next para. For experience, past experience, bidder of the offered rig should satisfy the following: A.1.21 or A.1.22, and whichever is applicable, and A.1.23. By my humble understanding of this clause is, my lord, the bidder should be manufacturer of either OEM, or the bidder should be a manufacturer of three major rig components. For the purpose of demonstrating the experience, a bidder is at liberty to either rely upon A.1.2.1 or A.1.2 and A.2.3. Am I clear, my lord?
Yes.
Now, what had happened in this case, my lord? Please come to page number 335. This is a communication by the oil, my lord, to us. When we said you cannot accept the technical bid of the MEIL, then they reply to us by saying this. Please come to the last two paragraphs.
Page.
Page 335.
Yes.
Against the above technical qualifying criteria, MEIL have submitted their offer relying on technical experience of their subsidiary company, Drillmac Incorporation USA, who is a manufacturer of OEM of mast, substructure, and crown block assembly. For the present, let us accept, my lord, Drillmac USA is his experience can be credential can be taken note of. So what was taken note of? That OEM part, original. Now please come to the subparagraph. For supplementing past supply experience against drawback, drawwork, top drive and drilling control system, MEIL's bid relied upon technical experience of subsidiary Drillmac SP8. My lord, I have experience as an engineer. I have worked as an engineer, but I have the experience as a, my lord, overseer. That is what has happened in this case. Drillmac SPS in experience is not in respect of, my lord, OEM, supplying OEM. Now, can it so happen that a party who is sought to be inducted as a technical collaborator, he has experience of manufacturing something and take experience of somebody who has experience of supplying something else?
No, that explanation is given by Mr. Sen.
Yes.
He is trying to say
Yes,
that you see this first part which you read
yes,
is the first requirement. You were referring to page 101.
yes, my lord. No, my lord, my learned friend by argument cannot improve their
No, that's
case.
okay,
This
but-
is
but-
their pleaded case.
No, but it is his submission that
Yes.
101, the first part,
Yes,
he should be in OEM for three things.
yes.
So if that is satisfied,
Ah.
he did not go to the second
No,
second
my
part.
lord, my lord, no, what I am trying to, perhaps I am not been able to make myself clear. To that extent, I have no quarrel. I have no objection against that. I am not complaining against that. Now, shouldn't your experience be also of the same experience of supplying, my lord, OEM? The experience is of something else. Experience of the banned entity is not towards supplying OEM. It is experience of supplying rig components. I'm on that. It is absolutely incongruous, my lord. Am I clear to your lordship, my lord?
No, there is no difficulty in understanding you, but you
Yes.
say I'm juxtaposing your statement with what Mr. Sen has said.
Yes,
The second part,
yes.
if it is or,
Ah.
so that itself can be omitted. The experience of
No, my
this.
lord, how can it be, my lord? Either no, the experience must be of the same, my lord, or you supply the same. Can it be, my lord? I have an experience of, supplying OEM. Sorry, manufacturing OEM, and I have experience of supplying, my lord, rig component. Well, I think it's logical, my lord. Anyway, my lord, this is
I don't
any-
understand because you see,
No, no.
if I'm manufacturing pencil,
yes.
definitely I'll be supplying it also somewhere.
No, it may be so for the no, my lord. In the last 3 years, he may not have the required number. It's a qualified, my lord. The criteria is qualified. If your lordship would kindly come to page 102, my lord. Oh, sorry. Please come to 101. The A.2.1.a. The bidder shall have an experience of minimum 10 years in manufacturing and supplying of mast and crown block assembly. That means his experience has to be of 10 years and supplying also for 3 years. 10 years in manufacturing and supplying. I can appreciate, my lord, if the experience of a Drillmac SPA utility band entity was also supplying, my lord, OEM, then there is no issue. Here they are supplying something else and they're having experience, sorry, they are manufacturing something else and, my lord, have the experience of supplying something else. So that way, my lord, the tender could not have been compliant of the tender conditions. Apart from the argument which I have already made, my lord. So, my lord, taking this example, the third argument of my learned friend, that tenders has to be interpreted in a manner so as to further competition, is always not, my lord. It's not a proposition which is, my lord, hold good all the time in all situations. It all depends upon facts of each case. At times it may retard competition. At times it may. So therefore, my lord, that proposition in my humble submission has no, relevance in the facts of the present case. In fact, my learned friend, my lord, relied upon clause A.2.5. In fact, my lord, our instruction is, my lord, the instant tender is a second tender, my lord. Prior to this, there was a tender. That clause was there. That is how it continued. Of course, my lord, there is a purpose. Now, my lord, that may not be. Anyway, my lord, this argument is not of much of difference. Then my learned friend made an argument, my lord, that there is a distinction between banning and holiday. Therefore, in the instant case, since it is a case of putting him on holiday, which in the comprehension of my learned friend, my lord, it's something, some sort of a lesser punishment, my lord, as we understand in service jurisprudence. Major punishment and lesser punishment. My lord, that is again wrong. Why I'm saying, my lord? If your lordship would kindly come to page 351 of the writ petition. Now, according to Oil India, according to the private respondent, this policy of 97 is holding the field. Now, please come to 5.4. Page 351.
Yes.
If an agency is put on holiday list, it shall not be considered for any tender of Oil India limited during the currency of the holiday period unless revoked. The ongoing tenders where the agency has participated shall dealt with in the same manner as given in subpara 2 and 3 of para 4.12. So, my lord, even if somebody is put on holiday, he is also required to be, my lord, not considered for any work. So therefore, my lord, where is the scope of showing any leniency, my lord? Then, my lord, will kindly come to page 76. Earlier, I referred to 351, my lord.
Yes, yes.
Now, my lord, will kindly come to page 76. My lord, 351 is a part of the oil's banning policy of 2017, and 76 is part of the tender, my lord. clause 37.0.
Yes,
Banning policy dated 6th of January 2017 as uploaded will be applicable against the tender. So there is a clearly professed mandate that 2017 policy will be applicable. Now please come to the subpara. Bidders who are on holiday banning suspension list of oil on the date of submission of the bid during the process of evaluation of the bids, the offer of such bidders shall not be considered for the bid opening, evaluation and award. If the bidding document were issued inadvertently downloaded from website, the offer submitted by such bidder also not to be considered for bid opening, evaluation and award of contract. My lord, I'm relying heavily on this, therefore I'd like to make one submission, my lord. Now, of course, it uses the expression bidder. Bidder is MEIL. MEIL is not in the banning list. Who is the banning list? It is the one of the subsidiary. Now, my lord will kindly come to page number 346, my lord. Clause 4.9.
yes,
If an agency is put on the banning list, the subsidiary, sister companies, joint venture, and holding company of the erring agency shall not be considered as banned. Now, my lord, agency has been defined, which your lordship will find at page number 342.
which page?
Page 342, my lord.
Yes,
Agency shall mean bidder, contractor, supplier, consultant, oil panel contractor, service provider, and vendors. So expression of agency is really very wide. Now, my lord, if we read clause 2.0.5, that is definition of agency, and my lord 4.9 and 4.12. What follows is, my lord,
just a moment, 2.0.5 with read with,
4.9
yes,
and 4.12.
yes,
Because 4.12 says an agency which is put on banning list should not be considered for any ongoing future tender during the ban period. So, my lord, 4.9 and 4.12, if it is read together, if it is read harmoniously, what follows is, supposing, my lord, supposing a parent company has a subsidiary, and subsidiary was the agency in a contract, as in the present case. Now, my lord, because of subsidiaries, my lord, ban, it will not have an impact on the parent company. But, my lord, it will definitely have an impact on the agency, that is the subsidiary, because of 4.12. It clearly says agency which is put on banning list should not be considered for any ongoing future tender during the banning period. Now, lordship will kindly appreciate, correlate the argument of the other side. The other side is relying on few judgments of the Supreme Court for the proposition that Supreme Court has said that in certain cases, certain entities can be recognized as a single entity. Therefore, the credential or technical, the credential of the subsidiary can be taken as a technical collaborator. For example, my lord, the law all started with New Horizon, then Master Marine, then my lord, the recent cases, CRCR, then my lord, Agmatel and all these judgments. Now, my lord, here we are concerned by a particular bid document and we are concerned by a particular banning policy. This will govern the facts of this case, not those general law rendered on different facts. That proposition that in a given case, a subsidiary's, my lord, credential can be utilized in a tender, that is in the facts of those cases. Those are not general proposition of law, rendered to be applicable in all cases. And it all depends upon what the tender conditions are. So, my lord, if we take note of this, what clearly emerges is that a banned entity's credential cannot be taken note of. No matter your idea may be to, my lord, ensure better competition, but that is again in the, my lord, wrong realm. So, my lord, as far as the OM of the oil is concerned, that is very clear and specific. Now, my lord, an argument was also advanced that sometimes in March 2020, the Drillmec SPA Italy merged with the bidder, that is principal bidder, that is MEIL. Therefore, my lord, what MEIL did, what Drillmec did, my lord, for that the MEIL cannot be penalized. My lord, this argument is too far-fetched, my lord. If Drillmec SPA Italy has earned any disqualification, it will continue to be there until, my lord, in accordance with law, either that is set aside or the period comes to an end. And in this case, my lord, on the date of opening of, assuming their argument regarding 2 months is all right, then also, my lord, on 2/5/22, when the financial bid was opened, then the banning order was still continued. Therefore, his financial bid could not have been opened. And because, my lord, clause 18.4 of the tender document at page 72 says only financial bid of those bidders will be open who are technically qualified. Then, my lord, guidelines of 2017 would govern the rights and obligation of the parties. Yes, my lord. Page 72. 72, clause 18.4.
If I don't see it, I don't remember.
Yes, yes. Page 18.4. Price bid of only those bidders will be open whose offers are found to be techno-commercially acceptable. If the technical collaborators' experience is set apart, then, my lord, this tender has to be thrown to the dustbin. It can't be further considered, my lord. Oil was so sanguine about awarding the contract to the private party that they were taking opinions after opinion. Too much of anxiety, my lord. Price bid of only those bidders will be open whose offers are found to be techno-commercially acceptable. Then, my lord, an argument was advanced that it is guideline of 2017 which alone will, my lord, govern the rights and obligation of the parties. Now, here, my lord, to appreciate this argument, lordship will kindly take note of 3 dates, my lord. 9/11/21, 9/11/21, respondent number 3 was banned. 15/12/21. Technical bid evaluated. 2/5/22. Financial bid evaluated. Going by 4.12 of the guideline of 2017, the technical collaborators thing could not have been taken note of, my lord. Therefore, my lord, the financial bid could not have been opened. Because, my lord, the other day I gave the dates, my lord. What had happened? NIT is dated 39/21. Then, my lord, debarment order is 9/11/21. Technical bid opened on 15/12/21. In between, my lord, 7/6/22 IEM hearing took place. Independent external monitors. Solicitor General's opinion on 22/6/22. LOA issued on 28/6/22. And on 29/6/22, IM decision was communicated. And my lord, next day, chairman retires. 36/22. Now, my lord, what follows is, on the day when the technical bid was evaluated, assuming, my lord, that 2 months period as envisaged by the new guideline was not yet over, let us give that benefit of doubt. But on 2/5/22, when the date for financial bid opening was going on, it was fixed, my lord, scheduled. And the clause 37 of the tender at page 3076 says, the position obtaining on opening of the financial bid was, here is a tender whose technical bid is defective. So it should not have been opened. So therefore, my lord, the argument that, my lord, it is only, 2017 will govern is not correct. Now, my lord, during opening my argument, I did not address your lordships on the other point. Now, my lord, will kindly come to that new guideline. 239. Please come to page 240, my lord. In the context of the above, all issues regarding debarment have been reviewed in consultation with the major procuring ministries, departments, and it is decided to issue attached debarment guideline in supersession to all earlier instructions on the subject. So it is something like a model debarment guideline, which will be followed by all department, all PSUs. Now kindly see, Secretary, Department of Public Enterprise, with a request to circulate these instructions to all central PSUs, including oil. Then my lord will kindly come to page 241. Now here I am making the submission to show even MEIL is not, my lord, competent to be. All along it was my case that DRILMEC SPA was not competent. Now, my lord, even MEIL is not competent. Because oil cannot blow hot and cold at the same time. When it comes to reducing the, debarment, you rely upon this guideline. That order you have not still placed before this honorable court, because lordships will get to know that this was by invoking this OM, my lord, the debarment was brought down to 1 year. Till that they have not brought on record, my lord. allied firm. All concerns which come within the sphere of active influence of debarred firms shall be treated as allied firm. In determining this, the following factors may be taken into consideration. Whether the management is common. In fact, my lord, by the first criteria, I'll satisfy your lordships that, my lord, management is common. Management of MEIL and they themselves say, my lord, they have taken it over. They have merged it over from 31st of March 2020. So our task has become easier. And common management. Yes. Now kindly come to page 244. It is a departure from clause 4.9. Clause 16. No contract of any kind whatsoever shall be placed to debarred firm, including its allied firm, after issue of debarment order by the ministry department. Bids from only such firms shall be considered for placement of contract, which are neither debarred on the date of opening nor debarred on the date of contract, even in the case of lease purchase, etc., etc. In case any debarred firm has submitted bid, same shall be ignored. In case of such firm is lowest, next lowest firm shall be considered. 18. Contract concluded before the issue of the debarment order shall not be affected. We will operate prospectively. So it is not a case, my lord, where the award of contract was prior to coming into force of the this guideline. Debarment said automatically extend to all allied firms. Then, my lord, will kindly come to page 245. So as I have already submitted, this is in clear departure from the clause 4.9 of 6/1/2017 guideline. All ministries department must align their existing department guidelines in conformity with these guidelines within 2 months from the date of issue of this guideline. Further, bidding document must also be suitably amended if required. That means, my lord, there was a cooling period of 2 months. This was issued on 2/11/21. Therefore, my lord, on 1/1/22, the 2 months period is over. To give the benefit of doubt, my lord, when the technical bid was opened on 15/12, this did not come into operation. But on 2/5/22, when, my lord, the financial bid was opened, this was very much holding the field. So therefore, in my humble submission, my lord, even MEIL is not competent to bid as a allied firm. Now, my lord, will kindly come to few clauses of this, 21 guideline, my lord. One second. My lord, will kindly come to 239. Please come to 246. Very good. First, my lord, will kindly come to page 283. These are the documents, my lord, which we got from, what is that entity called? From the ministry website. Ministry's website, my lord. United States of America. Italy. Like we have corporate affairs website, my lord.
This is an email. That one is also. Green light is also. That's next.
Now, my lord, will kindly come to page 283. Now, my lord, this is MEIL Engineering International Limited. That's the parent holding company. If your lordship would kindly come to page number 284. Page 283, my lord. Somewhere in the middle, slightly below the middle, MEIL Global Holding BV, as a lordship got it, my lord. Page 283, MEIL Global Holding BV, Netherlands, is 100%.
Yes.
subsidiary of Mega MEIL, that is petitioner number 2, my lord, respondent number 2.
Yes.
And then my lord will come to page 284.
Yes.
Towards the end, subsidiary of MGH, serial number 3, Dilmac SPA Italy. So, Dilmac SPA Italy is a subsidiary of my lord MEIL. Then my lord will kindly come to page number 288. In fact, they admit, my lord, they are not saying they are not admitting.
291.
My lord, towards the end, MEIL Infrastructure DMCC, then Dilmac INC USA, MEI Holding Limited.
You're reading where?
At page number 288, my lord. First column towards the bottom. 1, 2,
Yes.
3, 4, fifth from the bottom, my lord.
Yes.
MEIL Infrastructure DMCC, Dilmac Inc. USA, the MEIL Holding Limited. That's the US entity.
MEIL Infrastructure DMCC.
Yes. No, my lord, Dilmac Inc. USA.
Inc. USA.
Yes, that's a subsidiary of my lord, a mega respondent number 2.
291.
Yes.
Now, my lord will kindly come to page 291. Serial number 1, 2, 3, 4, 5, 1 B. Srinivas Reddy, whole-time director. Key management personnel.
Page.
Page 291, my lord. B. Srinivas Reddy. We are trying to show, my lord, that these are all common, there's a common management.
Will make it release.
No, 1 second. Then my lord will kindly come to page 292. Here also his name figure B. Srinivas Reddy, serial number 1, 2, 3, 4, 5. PP Reddy, VK Krishna Reddy, P. Deora, CP Subaya, then Srinivas Reddy.
Historical record of Dilmac Italy.
Now please come to page 297. This is the, my lord, the public record of Dilmac SPA Italy.
200.
297.
97.
President.
They call it Presidente Consiglio Amministrazioni. Boma Reddy, that's the chairman. Boma Reddy Srinivas. The same person, my lord. Boma Reddy Srinivas.
Yes.
304.
Then my lord will kindly come to 304, my lord.
About the shareholder. MEIL Global Holdings. And
Please see, my lord, MGH, MEIL Global Holding BV,
Just on which page?
page 304, my lord. Within that box towards the end, there is a name MEIL Global Holding.
Yes.
Yes. Then my lord will kindly come to the next page. 6, Amministrazioni. That means administration, perhaps. Presidente Consiglio, Boma Reddy Srinivas.
you can check that.
What the name?
Which is the MGT7 form of
Please, Government of India. Then my lord will kindly come to page 308, my lord. There is a Government of India record.
300.
308, my 309.
holdings.
Kindly see, my lord, there is a column called particulars of holding subsidiary and associate companies, including joint venture.
And then
It starts, my lord, My lord will kindly come to 312.
Read back. USC. And SP 18.
Kindly see, my lord, serial number 53, drill make INC, then serial number 63, drill make SPA. Am I clear, my lord? So, my lord, same owner, they are subsidiary, they themselves say, my lord, in one of the same management. Therefore, my lord, I will draw your lordship's attention once again to the 2021 policy.
Just a moment, 312, what you're trying to show?
312, I was trying to show, my lord.
Dilmek Incorporated.
Yes, Drillmac Inc. Serial 53 and serial 63 Drillmac Italy. SPA, these are all subsidiary, my lord. And at page 309, kindly see on top, MEL Holding
Yes.
Limited, that's the subsidiary. So it continues, my lord. So Drillmac SPA Italy is a subsidiary of my lord, MEIL, amongst others. And now lordships will kindly come to page 241. Clause 3.
Which page?
Page 241. my lord. I'm just, taking the indulgence of bringing your lordships again to this clause, my lord. Because this argument is directed for the proposition that even MEIL is not, my lord, eligible under this 2021 policy, which took effect after 2 months. Allied firm, all concerns which come within the sphere of effective influence of debarred firm shall be treated as allied firms. In determining the following factors may be taken into consideration: whether management is common, majority interest in the management is either of one attribute is enough. Then, my lord, I have already indicated at page 244 what is the consequence of debarment. At 16, no contract of any kind whatsoever shall be placed to a debarred firm, including his allied firm. So, my lord, my submission is, in terms of the 2017 policy, certainly Drillmac Italy's credential cannot be taken note of. Therefore, neither it can be recognized as a technical collaborator. Therefore, on that count, my lord, the tender is liable to be, technical bid is liable to be rejected. Alternatively, my lord, in terms of the new guideline which has come into force from 2nd of November 2021, even MEIL is not competent. Because as an allied firm of a debarred firm, even MEIL will, my lord, lose its efficacy as a eligible bidder, including that US component, my lord, including that US from whom that OEM thing was taken. So this is regarding this point, my lord. Then my learned friend argued about since MEIL doesn't have any technical experience, so for OEM, they have taken help of Drillmac USA. And for supply experience, they have taken help of their another subsidiary, Drillmac SPA Italy. As I have already submitted, in view of the reasons indicated, my lord, in both the situations, neither Drillmac USA nor Drillmac Italy can become a technical collaborator, having regard to the, my lord, tender conditions, which says it is the bidder, unlike in the Supreme Court says where what a single entity has been defined. Then my learned friend referred to, my lord, these judgments. Now, before that, let me make one submission, my lord. Before I deal with the submissions, my lord. Now, my learned friend also wanted to advance a proposition that if two views are possible on interpretation of a tender, then the one which favors the employees should be preferred. Has it started any judgment on this? No? My lord, to the best of my knowledge, subject to correction, of course, my lord, I am yet to lay my hands to any such authority. I can appreciate, my lord, when it comes to interpretation of fundamental right, if two views are possible, then view which furthers fundamental rights should be preferred. In a social welfare legislation, if two views are possible, then the view which is in the, which will further the purpose of the act will be preferred. I am also aware of the proposition, my lord, that in a taxing statute, if two views are possible, the view which favors the assessee should be favored. And in case of exemption, if two views are possible, the view which favors the revenue should be favored. But in case of a tender condition, my lord, I am yet to come across any decision. I would be enlightened, my lord, if such an authority is put forward. In any case, my lord, while taking that view, public interest should be the guiding factor. And public interest can be best subserved only by following the tender prescriptions, which will be consistent with Article 14. My lord, this idealism will not do in a tender work, my lord. Yes. That's why Supreme Court says, my lord, when it comes to power of judicial review, there is no bar, my lord. It's the self-restraint of the Honorable Court. Because Lordship gives due deference to the views of the authority, because Lordship is not expert on a subject. Now, in this case, your Lordship is called upon to decide a dispute where admittedly an entity is debarred. When the, my lord, guidelines of the organization says a debarred entity cannot be a part of the tendering process. Now, in such a situation, is there any scope of bringing all those, my lord, judgments? To just for the sake of defending a decision. When the Solicitor General of India, one of the highest law officer of the country, my lord, he himself said, the view which we are trying to take, it might lead to some litigation. And we rightly, my lord, we are before Lordships. Therefore, my lord, this in my humble submission may not be the correct position, my lord. Then my learned friend has said that
So we will continue at 2 because I have a meeting at
My lord,
1:15.
my lord, can I make one small prayer? There is a special bench at 2 o'clock. Could you also give me half an hour time, my lord? 2:30 or 2:35 I'll come. I'm deeply open. Huh? Sure. I will come. My lord, immediately as soon as I come, my lord, I'll report. Deeply open. Half an hour. Second to more about the number second to into case. Second to more the point, eh? Oh.
Original record has sent to the essence from extending counsel, my lord. So he has not returned the original record. His record is kind of
Your matter is over?
Yes, my lord. In fact, my lord, that will have taken time. I have taken time there.
Okay.
Otherwise, at least that can wait, sir.
Okay, then I'll take it up after some time.
Yes.
This is continuing item. Dr. Goswami, you are in this matter. Just wait for some time because this is continuing for some time.
My lord, before I go to the judgments, let me place one fact, my lord. What is that? Please, कहाँ है ये?
Page 9.
हाँ, आइए।
Please reply to some.
Our-
I'll reply to them. Please.
My lord will kindly come to page 910, my lord, running. And refer to your lordship's interim order.
Yes, and I've
Yes,
seen that.
yes, page 915, my lord. Para 12. Just can reply back now that it is there. Page. Page.
What is that page?
Page 915, my lord. Para 12. Therefore, on a conjoined reading,
Just a moment.
well, on subsequent page. Para. ठीक है. Para 46.
Yes. So,
Please come to para 12, my lord.
yes.
Therefore, on a conjoined reading of the contents of clause 3 of OM dated 2/11/21, as clause 25 of the guidelines appended to the said OM, preface it appears the department guideline dated 6/1/17 of respondent number 1 would not be deemed to be superseded by guideline appended to OM dated 2/11/21 because of prescription in clause 25 thereof, that all ministries departments were required to align their existing department guidelines in conformity with the said new guidelines within 2 months of its issue. Moreover, there appears to be no material on record that the bidding documents in respect of the bid in question has been amended. Therefore, in absence of any materials on record to show that respondent number 1 had adopted the new department appended to OM dated, the court is disinclined to presume that by virtue of OM dated 2/11/21, department guidelines dated 6/1/17 of the respondent number 1 stood automatically superseded on and from 2/11/21. Therefore, at the interim stage, my lord, this was the view which your lordship has taken. Now, my lord will kindly take the affidavit in opposition filed by oil, my lord, at page number, my lord, 30 and 30, para 46. Affidavit by the oil miner.
Yes.
I'll have your lordship's kind attention to para 46 at page 30 and 31. last three lines, my lord, at page 30, the sentence starting with regard to the allegations.
Yes.
With regard to the allegation that the order dated 21/2/22 of the appellate authority against respondent number 3 for reduction of debarment period, the deponent states that it was observed by the appellate authority that competent authority should have correlated the severity and number of transgression before deciding the period, as Integrity Pact provided for a period of debarment from 6 months to 3 years. Therefore, the appellate authority did not find punishment imposed on the respondent number 3 commensurate with the severity of the transgression. Now, this is important. The 2021 debarment guideline was noted in the order as a reference only, which did not form the basic reasoning for reduction of the period of debarment. Further, reference of 2021 debarment guideline in the order did not cause prejudice to the respondent, but application of the guidelines to debar respondent number 2 would have caused prejudice to the respondent number 2. Thus, the respondent did not approbate and reprobate on the same situation as alleged by the petitioner. Now, my lord, your lordships, while considering the interim prayer, my lord, was of the view that materials are not before the Honorable Court to take a view that 211/21 guideline has been, implemented. Now, my lord, this is the stand of the Oil India in the affidavit, where they say the reference to 2021 guideline was only by way of it was a casual reference. Incidentally, nothing turned out on that. My lord, by application of that guideline only it was reduced. And my lordship will kindly take note of one more thing. It's a certiorari jurisdiction. It is the responsibility of the respondent to produce before a lordship each and every materials which has a bearing on the record. If they do not, my lord, produce the record, lordship will draw an adverse inference. It's something like, my lord, Evidence Act. They are not leading evidence because it may go against them. That explanation to my lord, that section, I forgot that section. 114G.
114G.
Similarly, in a certiorari jurisdiction, my lord, it is the duty of the respondent to produce the records.
Mr. Chaudhary, please show me that the reduction was done by this guideline, that part.
No, that, yes. Now, the appeal, no? Please come to page 237. This is their view.
This is the 2021 guidelines, which is the reference line.
You had said earlier
Yes,
that the reduction of reduction
from
this-
3 years to 1 year.
that document was not placed by them.
Never. Never. I have even, while opening my argument, I made that point. Today
Yes.
also I'm doing. They have not done it. And my lord, they say reference was for reference to 2021 guideline does not mean that based on 2021 guideline they have done it, because they have gone by the severity of the consequence. No, this is one of the records.
This is the reference to this year, 21. Published light. This is the new.
This is,
Which one on page 239.
239. Yeah, but it's 239.
It's not the department guidelines.
No, 213, 213. 239.
Series.
But our contention was somewhat different. My lord, your lordships did not pass the interim order because at that point of time, your lordships had taken the view that there is no material on record. Now, my lord, the materials on record today also it is not there. But my lord, in my humble submission, it is the duty of the oil to produce it before your lordships, which they have not done. Now, question is, my lord. Now, let us summarize the facts. There was a tender. Amongst others, my lord, the tender provided that the bidder must be a manufacturer of OEM, or the bidder must be a manufacturer of 3 major brick components. In addition to that, my lord, there is a clause. Not only the bidder should have the experience of manufacturing, bidder should also have the experience of supplying. Now, admittedly, my lord, MEIL, that is the bidder, that is the parent holding company, it does not have any experience. But yes, its subsidiary Drillmac USA is a manufacturer of, my lord, original equipment. Whether it is for 10 years or not, that we are not very sure, but they say they. And when it comes to experience, my lord, they have taken the credential of a banned entity, that too for, my lord, supplying 3 rig components, not, my lord, major original equipments, that is the mast and all. And in addition to that, my lord, the tender also provided in A.1.2.3 that in respect of other requirements, even if the bidder does not possess the eligibility of its own, it can take help of somebody else. Then, my lord, when it comes to financial bid, the tender is very specific, very unequivocal. It says, if a subsidiary does not meet, my lord, the financial requirement of its own, then, my lord, it can take the help of a holding company. Therefore, here we are concerned with a tender where the tender specifies what the bidder should possess and which all are the components of the service which can be of others. So, my lord, in such a scenario, to take help of any other decision, in my humble submission, would be a wrong approach, because every decision has its own facts. Now, on top of that, my lord, there is a clause called clause 18 at page 72, where the bid document says, my lord, only those bid would be open who are technically responsible. So this was not done. Admittedly, my lord, on 9/11/21, the successful bidder with whom the work has been awarded, it was banned for 3 years. The banning was to continue up to normally for 8 years. 3 years. So 3 years will take us to, my lord, 21, 22, 23, 24. Now, my lord, an appeal was filed. Based on that appeal, the period has been reduced to 1 year. That 1 year will come to an end on, my lord, 8/11/22. So, my lord, going by, my lord, clause 37 of the bid document, which says, even during evaluation also, if there is some disqualification is earned, even that can be taken note of. Not that, my lord, if on the date of submission of the bid, no eligibility is incurred, no disqualification is incurred, that will debar, no. Even during process of evaluation also, if some disqualification is incurred, in that case, that can be taken. So definitely, my lord, even if we give, my lord, the advantage of that 2 months period, that means 1/12/22, by this time technical bid was evaluated. Therefore, maybe, my lord, we can say that technical evaluation to that extent was okay. But on the date when the financial bid was evaluated, certainly, my lord, that disqualification would come into play. Therefore, it cannot be, his bid could not have been considered. Along with that, my lord, the 2 other associated issue is whether guideline of 27 alone is applicable or 2/11/21 is applicable. I have already submitted, my lord, by application of this 2017 guideline at Drillmac SPA Italy, there is no question of considering their case because it's a banned entity. And going by the 2/11/21 guideline, even my lord, MEIL itself is as a allied firm, my lord, is debarred because the banned entity is an allied firm. So that way, my lord, that tender itself is not required to be considered. Now, it is in these facts, lordships will have to take a call whether the action of the authority in awarding the contract despite all these changes is correct or not. On top of that, my lord, they are relying heavily on the opinion of the Solicitor General of India. The Solicitor General of opinion I have already read out, my lord, that itself, my lord, raises so many questions. Rather, it says, if you go ahead with this manner, then it is likely that Vail will, go for litigation, and that is rightly so, my lord.
I said Department of Public Enterprise.
Then, my lord, another aspect of the matter is, lordship knows in these matters normally IEM, there's a concept called IEM, my lord, they have a rule. Now, here in this case, kindly see their conduct, my lord. Yes,
That perhaps may not be within the scope of examination.
yes. 421. The crucial issue here, page 421, my lord. The other petition. Please come to page 421, my lord, the last paragraph. The crucial issue here is whether guidelines automatically supersede oil's banning policy. The IMs are not equipped to examine and authoritatively rule on the complicated legal matters. Oil should therefore examine the issue in detail, following appropriate procedure in consultation with Department of Public Enterprise, and take a considered decision based solely on the merits of the case. I'm sure, my lord, as suggested by the AM, they did not approach their administrative ministry. Instead, my lord, in my humble submission, my lord, the manner in which the circumstances under which the LOA was issued, my lord, it can't be construed as a bona fide action. There is a tinge of, my lord, arbitrariness. There is a tendency to, my lord, somehow help this private respondents number 2, my lord. Why they did not approach the, my lord, this administrative department? They could have said, and going by the forwarding letter of 2/11/21, it clearly suggests, my lord, that within 2 months the PSCs will amend their, my lord, existing guidelines. The idea of giving that 2 months was to, my lord, ensure that after 2 months the new guideline will take over. And the opening sentence of the, my lord, that OM clearly says it seeks to supersede all the existing guidelines on the subject. So that was supposed to be taken as the model, my lord, guideline, and which is to be adopted by the all PSC. So in these factual metrics, my lord, to recognize a bona fide exercise of power by the oil is, in my humble submission, is not correct.
Yes.
Here is a clear case where they sided with the private respondent, my lord, and materials are, my lord, galore. So therefore, it's a fit case where lordship will interfere with the decision-making process. Here, my lord, in my humble submission, the decision is bad on account of 2 judicially recognized grounds. One, illegality, and other is irrationality. It is hit by the principle of witness by unreasonable. How can oil, my lord, take a view that a banned entity can take part in a, my lord, a tender process, when their own guideline says you can't?
And by that.
My lord, even, my lord, whatever broad meaning we may like to give to clause 4.9, MEIL may come in, but not that entity which is banned. Because what meaning you give to 4.12 then?
Just one moment.
Yes.
This, is that general financial rules of 2017 on record?
Yes, yes. It is there on record, my lord. I think Lordship has asked a very pertinent question. The very previous page, my lord. कितना था?
32 madam.
232.
Yes. Two 237, my lord. Hey, it will formal explain. At page 237, my lord.
Yes.
Rule 151, my lord. A bidder shall be debarred if he has been convicted of an offence. So a bidder debarred under subsection 1 or any successor of the bidder shall not be eligible to participate in a procurement process of any procuring entity for a period not exceeding 3 years, commencing from the date of debarment. Department of Commerce will maintain such list, which will also be displayed on the website of DGSND as well as Central Public Procurement Portal. A procuring entity may debar a bidder or any of the successor from participating in any procurement process undertaken by it for a period not exceeding 2 years if it determines that the bidder has breached the code of integrity. The ministry department will maintain list in which will also be displayed on their website. The bidder shall not be debarred unless such bidder has been given the reasonable opportunity to represent, etc. Enlistment of Indian agents, etc., etc. Purchase. So, my lord, these are the guidelines.
Then, Mr. Chaudhary, there is another picture which is emerging.
Yes.
If you come to page 417, you have referred to
1 second. My lord. Yes.
that third line from below,
417, my lord.
417.
Yes.
uh,
Moreover,
Moreover, yes. The
yes,
last line.
moreover, banning period of drill make SP Italy has been reduced from 3 years to 1 year from Milan by Oils Authority in view of so and so. A well contended the debarment period for a drill make Italy should be 2 years from Iman under the provisions of rule so and so, and hence reduction of debarment period of to 1 year is not in line with GFR. Yes.
Yes. So this means that not although the tender documents and their development rules do not were not amended, but still it is the IEM which has taken note of the fact that the appellate authority used this GFR 2017.
Okay. Yes. So, but Vale's perspective was going by Vale's, 2017, you could not have reduced it to 1 year.
No, that's okay. But now we have that answer.
No, Lordship is saying a different thing.
Means now we have an answer. There is now an answer how 2017 was brought in.
Yes.
And the IEM says that it is from their record. So therefore, even if it is not produced, you can infer that 2017 was taken into.
Malas, in fact, Hale's own representation at page 210.
Okay.
There it talks about the usage of GFR 2017. What my learned friend, what fell from my lords. Sorry.
No,
Page
my lord.
210.
No, my lord. No, I am not disputing this proposition. What I am trying to say is, if we go by, my lord, this 17 guideline, then certainly their tender is non-responsive because you can't take note of a debarred firm's entity. But what I am saying is, assuming your lordship is inclined to hold that 21 guideline is applicable, in that case also, my lord, MEL itself is not eligible. That is my argument, my lord.
Correct.
Yes, that is my case, my lord. Now, my lord, let me come to the decisions. What is the law on this subject, my lord? My lord, let's not only read those judgments where the honorable court has brought in some restraint on the power of the court, my lord. First, my lord, I will rely upon first, I'll rely upon, my lord.
Just a moment, I'll just record that 417 and
Yes.
210. Yes.
By legal inference, we are seeing it must be. That has been the point. My lord will kindly have 1997 1 SCC 738. Asia Foundation, my lord.
1997 1 SCC.
1997 1 SCC 738. Lordship knows in this case, the money was coming from Asia Development Bank. Therefore, my lord court did sounded some caution for the courts. But even then, what was said in paragraph 10, my lord?
Yes.
Now, if your lordship would kindly come to page 746. My lord, Tata Cellular is quoted. The duty of the court is to confine itself to the question of legality. Its concern should be where decision-making authority exceeds its power, committed an error of law, committed a breach of rules of natural justice, reached a decision which no reasonable tribunal would have reached, or abused its power. Therefore, it is not for the court to determine whether a particular policy or a particular decision taken in fulfillment of their policy is fair. It is only concerned with the manner in which those decisions have been taken. The extent of duty to act fairly varies from case to case. This is very important, my lord. The extent of the duty to act fairly will vary from case to case. Shortly put, the grounds upon which administrative action is subject to control by judicial review can be classified as under illegality. This means the decision makers must understand correctly law that regulates his decision-making power and must give effect to it. Irrationality meaning witnessed by reasonable unreasonableness and procedural impropriety. The above are the only broad grounds, but it must not rule out addition of further grounds in course of time. Therefore, my lord, to say that the power of judicial review has been circumscribed is not at all correct, my lord. If there is illegality, then it has to be, my lord, addressed. Now, eventually what it says in para 10. Therefore, though the principle of judicial review cannot be denied as far as exercise of contractual power of the government bodies are concerned, but it is intended to prevent arbitrariness or favoritism, and it is exercised in larger public interest, or it is brought to the notice of the court that in matter of award of a contract, power has been exercised for any collateral purpose. So, my lord, all these components are present in this case. Kindly see, my lord. Is it so unintelligible? The eligibility criteria in the tender, is it so unintelligible? Their own guideline of 17, is it so unintelligible? 4.12, a bidding entity, a banned entity cannot be a part of the process. Why do we need the opinion? You have sought opinion on the point whether in case of a parent company and subsidiary company, either of them having experience, whether can be taken note of. There is no dispute. In a given case, if the tender conditions permit, it could be. But did you point out that there is a debarment order? Are you not aware of it? That the entity is banned when your policy 4.12 itself says. I'm not going to that allied firm aspect. It's a banned entity. So therefore, my lord, to prevent arbitrariness, 226 powers will always be available. To say that that power has been taken away or a restricted meaning has been given to that power, in my humble submission, is not correct, my lord. Then, my lord, what are you saying that one? Based on the rules only, that means to enter. My lord, next is 2001, 2 SCC 451, that West Bengal case, my lord, para 24.
2000.
2001, 2 SCC 451, para 24.
Yes.
The controversy in this case has arisen at the threshold. It cannot be disputed this is an international competitive bidding which postulates keen competition and high efficiency. Bidder have or should have assistance of technical experts. Degree of care required in such a bidding is greater than in ordinary local bids for small work. It is essential to maintain the sanctity and integrity of the process of tender and also award of the contract. The appellant respondents number 1 to 4, respondents 10 and 11 are all bound by ITB, which should be complied with scrupulously. In a work of this nature and magnitude, where bidders who fulfill pre-qualification alone are invited to bid, adherence to instructions cannot be given a go-by by branding it as an pedantic approach. Otherwise, it will encourage and provide scope for discrimination, arbitrariness, and favoritism, which are totally opposed to the rule of law and our constitutional values. The very purpose of issuing rules instruction is to ensure their enforcement, lest the rule of law should be a casualty. A relaxation or waiver of a rule condition so provided under ITP by the state or its agency in favor of one bidder would create justifiable doubts in the mind of other bidders, would impair the rule of transparency and fairness and provide room for manipulation to suit the whims of the state agencies in picking and choosing bidder for awarding contracts, as in the case of distributing bounty or charity. In our view, such approach should always be avoided. Where power to relax or waive a rule or a condition exists under the rules, it has to be done strictly in compliance with the rules. We have therefore no hesitation in concluding that adherence to ITB or rules is the best principle to be followed, which is also the best in public interest. So, my lord, I think this is the best answer, my lord.
Project clarification, Jaipur.
Now, my lord, my learned friend must have relied upon MG Project's case, my lord. Before that, my lord, I'll have your lordship's kind attention to the specific relief act, my lord. Kindly have section 41, my lord. In 2018, my lord, there was an amendment. Please come to section 41, clause HA.
Yes.
An injunction cannot be granted if it would impede or delay the progress or completion of any infrastructure project or interfere with the continued provision of relevant facility related thereto or services being the subject matter of such project. So, my lord, even Act was amended. In case of infrastructure projects, normally the mandate is interim order should not be passed. That is only interim order. And my lord, NJ projects is entirely a case based on this analogy. Now, my lord, there of course an observation has been made that even if an action is taken arbitrarily, then parties should go for civil suit. My lord, if that view, I think that has been clarified by subsequently, my lord.
Once you are in that book,
My lord.
once you are in that book, Specific Relief Act,
Section 14, my lord.
no. The introduction that statement you are making. The statement you were earlier making
Yes.
is from that introduction.
Yeah.
First line of that introduction.
Of section 41, my
No,
lord.
no. Preface of this book.
Okay,
is
okay.
Introduction. After the amendment, just before section 1,
Yes.
after the amendment.
An act to define and amend or recognize certain kinds of specific relief.
No, after that, 1 or 2 pages after that.
Okay. Maybe you are holding. I couldn't follow, my lord.
Introduction of that act,
Introduction.
just before section 1.
Specific Relief Act was enacted. That's the line, my lord.
No,
To provide for remedies to person.
no. I think you are, just give it to me. I don't know how these people are doing it. They've altered the paragraph.
Okay.
First line.
A mature legal system endeavors to provide not merely remedy for the every right infringed, but also an adequate remedy. It was in this process of
Only
charge
that much.
for effective remedial action, specific relief emanated from the equity courts in England.
Only that.
Correct.
That four lines.
Yes. Now, my lord.
That's why when you were making that argument, I was saying that it's introduction to Specific
Yes.
Relief Act.
And my lord, the NJ exports was explained by Honorable Supreme Court in a later judgment. A copy has been given, my lord. Jai Bholenath. Yes, please take the judgment, my lord. The challenge in the present appeal is to an order dated 33/22 passed by the High Court of Bombay at Aurangabad, whereby the writ petition filed by the appellant was dismissed, relying upon an order passed by this court in NJ Exports versus Messrs. Vinod Kumar so and so. Now, my lord, may kindly skip that portion. Kindly come to page 3.
Second paragraph.
Subpara, yes. We have heard the learned counsel for the appellant. We find that the High Court has totally misread the judgment of this court. Respondent number 4 was declared eligible in a flagrant violation of principles of natural justice and all fairness in process of determining the eligibility of tender, bid of respondent number 4 was accepted when at the time of opening of the technical bid, said respondent was disqualified. Therefore, manner which the bid was accepted shows arbitrary exercise of power. That the same Honorable Supreme Court, same bench has explained this position. So we say more or less same facts. Here we say the tender bid of respondent number 2 should not have been accepted. So there, my lord, this principle do not count. That limited scope of judicial review and or whatnot. No, the other judgments are little bit less. Monte Carlo. Last. So my lord, to put it in a very simple word, the two judgments which the Solicitor General refers to in the judge, in his opinion, my lord, it refers to judgment where the Supreme Court was considering in what situation a subsidiaries, which otherwise, my lord, do not suffer from any disqualification, whether the credential of subsidiary can be taken note of for finding out the suitability of the principal bidder. Here we are concerned with a situation where the subsidiary is suffering from some disqualification. In such a situation, whether those analogies will apply. That is, in my humble submission, is the core of the issue, my. So that's why it is said, my lord, a judgment is an authority for what it actually decides. Every statement, every observation is not a ratio decision. Now, my learned friend on both sides, my lord, they have referred to the judgment. For example, Monte Carlo, then my lord, CCL Corporation, then Consortium of Titagar, and APCON. These are all, my lord, judgments on the point where a particular view has been taken by the, my lord, employer, which is otherwise consistent with the tender conditions. Maybe there are some aberrations here and there. And having regard to totality of facts, Supreme Court says, in these circumstances, the High Court's interference was not called for. That is not the case here. So therefore, those judgments may have laid down a law to the extent that limited judicial review is permissible, but those will not apply here. Here the issue is, if one of the entity is a banned entity, then my lord, these judgments do not come into play. Then my lord, what else did he say? Now, my lord, one judgment, 2022 5 SCC 362. This is also more or less on the same line, but I'll read one paragraph, para 26. 2022 5 SCC 362. After referring to my lord Monte Carlo, Jagadish Mandal, and all these cases, Shilpi Construction. Now, my lord, here basically the issue was the interpretation of a clause in the tender which has been given by the employer, that is normally should be accepted. A due deference should be given. It is in that context, if your lordship will kindly come to para 26 at page 384. The above mentioned statement of law make it clear that author of the tender document is taken to be the best person to understand and appreciate its requirement And if its interpretation is manifestly in consonance with the language of the tender document or subserving the purpose of the tender, the court would prefer to keep restraint. Further to that, technical evaluation or comparison by the court is impermissible. If the, my lord, employer says black or white, then what happens? It's something like, my lord, in a descriptive answer, one a student must have thought, I wrote a very good answer out of 10. I should have got 8. The invigilator has gave him 7 out of 10. Their judicial review will not apply. Those are the situations which is visualized by this type of observations. So, but in a situation where an entity which is not even qualified is sought to be made qualified, certainly these principles will not apply. Then, my lord, the other 2 judgments I have already placed, New Horizon and all I need not. Therefore, my lord, to sum up, my argument is, my lord, very simple. Here is a case where in total arbitrariness, my lord, a tender of an entity which is not otherwise, technically responsive, has been made responsive and has been awarded the contract. And my lord, the writ appeal, my lord, this honorable court has already observed, any action taken will be subject to the outcome of the writ petition. It reads, my lord, however, it is provided that any action taken by the parties shall be subject to further orders that may be passed by the learned single judge in the writ petition. So therefore, my lord, it's a fit case where lordships will interfere with the decision-making process and set aside the tender, my lord, award, and remand the matter to the authority to take a fresh decision. And my lord, the fact that they may have done some work that hardly makes any sense, because there is always that order of division bench is there. In spite of that, if they have taken the chance, it is their call, my lord. So therefore, there is nothing to, suggest that any equity should be considered, my lord, at this stage. If your actions are illegal, then you face the consequence. And my lord, one final submission, my lord. My learned friend was also trying to make a submission that apart from the PSUs, they are also trying to encourage private entities. My lord, once we describe these transactions as commercial transactions, what is the scope of those arguments, my lord? Award of contract is a commercial transaction. That's why in Tata Silver it is said, the extent of duty to act fairly depends upon case to case. There is no standard set, my lord, because state is a litigant, therefore there will be a separate standard. No. Whether you are a state, whether you are a PSU, whether you are a private entity, the moment you submit a tender, you will be treated at par. Therefore, my lord, these arguments, my lord, is neither here nor there. On the contrary, my lord, by such argument, what is discernible is an attempt to support a party, which should be avoided at all costs, my lord. That is my humble submission. One more sentence. What is that? Space. I'm just taking 1 minute time, my lord. 2:39. What is that time they say? Attention is drawn to Sabna. So the guideline. You mean to say guideline itself is a rule. Yes, my lord, my learned friend has requested me make one point clear. Now, my lord, the guideline of 2021, it is based on the general financial rule. So it has got a statutory backing also. In fact, my lord, our High Court has rendered a judgment. What had happened in this case, my lord? For procurement of uniforms for the school children, GFR provides a guideline, rules. It says, my lord, Lordship knows under the RT Act this concept of a school management committee.
Local bidders.
Yes. Now, my lord, There, my lord, the idea is to decentralize the procurement process. Our High Court has interfered with the tender issued by the Assam government, where, my lord, bulk purchase was sought to be made. Why it was done? Because, my lord, these prescriptions are by General Financial Rules of 2017. Similarly, my lord, 21121 guideline is also pursuant to, my lord, GFR 2017. Of course, that is a aspect which your lordship will consider, as I have already submitted. QA 2017 guideline, my lord, drill make SPHL is out, and QA, my lord, 21121 guideline, even MEIL is also out, even including that US entity. So that is my humble submission. And regarding the other case, my lord, where Dr. Saraf has his client has challenged, my lord, the debarment order. There, my lord, I am raising a point on maintainability of the writ petition.
Let me
If your lordship permits me, I can just take 15 minutes time. There is one aspect is one suppression of material fact. And in view of the judgment of the Supreme Court, my lord, that even an administrative order also the doctrine of merger applies. Therefore, that writ petition is not maintainable, my lord. Because the original order of 9/11/21, it merged with the final appellate order. Appellate order is not under challenge, though writ petition was filed after the appellate order.
I think you are intervener, huh?
In fact, my lord, I have challenged that order because these are interconnected. Because supposing if my lord they succeed in that petition, it may have some bearing on the merits of this case. Therefore, these are all interconnected. That's why I made that submission. And there is a clear suppression, my lord, concealment of fact. So I'll rely on that KD Sharma's case and Kuni Ahmed for that doctrine of merger. If your lordship give me 10 minutes time, I can just indicate that. My lord.
No, first of all, just a minute. My lord, first of all, he's my learned friend is arguing about on the maintainability. You must know that he's an intervener in the petition. Now, intervener, as your lordship knows, either he can support the respondents or any side. He cannot make out his own case before the court. If necessary, I will place the judgment. I am not aware that he's going to start saying that the intervener also may argue about maintainability. They are judgments of the apex court. What is the role of the intervener? Whether intervener can make out his own case about the maintainability. Secondly, my learned friend again and again saying that they have suppressed the material facts about the 2021 the appellate order. Lordship, when the petition was moved, the appellate order was not served on the petitioner. Now, the Oil India produced the order before the court, which will be apparent from the interim order which was passed. My lordship may kindly see, my lord, the order which was passed in the second petition, my lord. In the second petition, the order dated 26/2022. WBC 4021 of 2020.
Is there a bar? Intervener cannot plead his own case.
Well, I will place, cannot plead. I will place this judgment of the Supreme Court.
Show me that.
Well, today I was not thinking that he was going to start.
No, because you see, once a maintenance is issued, then he'll have a right to
I will submit you. What is the role of the intervener? Whether the intervener can either he has to support the case of the respondent on any one side, but he cannot make out his own. In fact, the pleadings also, the Supreme Court said that he has no right to make separate pleadings also in the court. I place, my lord, that one. But for the timing, you lost me see the next petition, my lord.
Anyway, my lord, my learned friend can make his submission. Let me complete my part. I'll just take 15
No, how
minutes.
it can be? It can don't make a
No,
shortcut.
no, you make your submission.
No, don't make a
Against my
shortcut.
submission.
Let
Not
us-
stopping you.
We'll start it. You make the submission of maintainability. Everything you can make submissions.
This is 4201.
My lord, as my
402.
understanding goes, my lord, we cannot seek an independent relief as an intervener. Other than that, I can do everything.
But I'm submitting for lordship.
We can assist the court.
I can
My
understand.
lord, it will be, my lord, totally a meaningless exercise to take such a stand. in a court.
My lord,
Suppose, my lord,
Is there a case law? I'm not aware of it.
no, I am also aware of it, my lord. I cannot set up my own claim. I cannot seek a relief, but I can certainly assist the court in whatever manner
My lord, you
the
are
court
also-
feels, my lord.
At least On that ground, whether he can, my lord, I never heard that intervener, my lord, starting the petition and saying that no, the petition is not maintainable when the respondents have not argued at all. Well, intervener cannot in the beginning start and say that the petition is not maintainable and you also may hear it.
All right, you start your.
Yeah, naturally, that is the
Okay,
usual.
okay.
that is the
I'll
usual
make my
system, na.
submission.
You must have some other case, so you want to finish it and go.
No, there's nothing like that.
My lord, he
No.
must have some other matter here.
So do
So
you
he
grudge
thinks
it?
that if 15 minutes.
Do
I
you
finish-
grudge it?
My lord,
Do you grudge that?
not grudge, but my lord, I don't want to leave him. He should remain here. When we have patiently heard him for 2 hours. And now at least he must also tolerate us.
Well, we have a forum down below in the ground floor. If you don't want to leave him, there's a forum down below in the ground floor.
Ground floor, my lord, that is not properly working, no? You'll also see the order dated 26/2022 in 4021. And in fact, in the records, if you'll also look into it, that you'll also find the order. Para 5, my lord.
Oh, this is order dated
26/2022,
26, yes.
para 5, my lord. Has you also got it?
Yes.
Mr. Samal and a counsel for the respondents have submitted that the petitioner preferred an appeal against the impugned order did so and so. In the meantime, an order has been passed by the appellate authority in the said appeal on 71/2/2022. By the appellate order, the appellate authority has reduced the duration of the debarment of the petitioner from 3 years to 1 year from the date of the impugned order did so and so. Impugning view rule 151(3) of the General Financial Rules 2017. In such view, the matter, the petitioner may not have any grievance with regard to the order of department. It is submitted by him that it is open for the respondent authority to take recourse to Article 20 of the Constitution of India and Section 6 of the General Closure Act. If you also look into the record, you'll also find the copy of the order, appellate order, which was produced before the court. And in fact, my lord, yes.
Yes.
My lord, I don't know whether, but it was placed before the court. The court kept it in the records also. Now, one point, my lord, because my learned friend has argued and there is no reply to reply, I don't want to make a reply also. Well, my learned friend submitted that the dividing policy of 2017 are not statutory. Are statutory in character. My lord, my learned friend was arguing one case. I think that is Assam Air Corporation in the morning only, because I'm not a regular in the tender matters. My friend is regularly doing the tender matters. There's the same debarring policy of 2017 of the Oil India Limited was applied for blacklisting the petitioner. And my friend was appearing on behalf of the petitioner there. In the court, in that case, came to the conclusion, my lord, that unless and until the terms and conditions of the tender documents are amended, the same will not take its effect. It was also observed therein that this is not a statutory one. I will give a copy of the judgment to my learned friend also, and thereafter liberty may be granted to submit a copy of the judgment before Lordship with a copy to the.
But general financial rules has a statutory force.
My lord.
General financial rules has a statutory force.
In that judgment, the question that my lord, integrity pact of 2017 itself of the Oil India Limited, that was in the subject matter of the examination. The same, which is subject matter of interference in this case, my lord. The same integrity pact of 2017 issued by the Oil India Limited was a subject matter of examination. The only difference is that at present I am appearing, in that case, my learned friend was appearing.
There is a certain issue where two bills can be taken while we are in the text. It's a yes, sir. It's a yes. If you make an immediate question, this will be the next second thing. That's a presentation.
Okay.
Only one judgment, my learned friend was facing lines for 1997 one. Not arguing it. I am only showing that that judgment itself was considered by the apex court in the compilation page 265. Page 294. (23 and 24) paragraphs. Paragraph 23 and 24 at page 293.
Two 93.
293, Miro. 294, I'm sorry, Miro. 294. I'm sorry, Miro. 294, paragraph 23 and 24. Only point out, my lord, that all earlier judgments, in fact, have been considered by the Supreme Court in one way or other. And when any judgment is rendered by the apex court after considering the earlier judgment, then in my humble submission, my lord, the judgment of the subsequent judgment of the Supreme Court, which after considering the earlier judgment is given, that is binding. One cannot, say that no, earlier the judgment was there, and subsequently, because subsequent judgment, when it considers the earlier judgment, and thereafter gives it, my lord, this decision, then that becomes binding.
You are referring with context of the case of Jai Bhagwan.
Asia, my lord. 55.
No, you are referring to in
My lord,
context of what
my lord,
proposition?
my lord. No, my submission was also the judgment which my learned friend was in 1997 on SCC. Since the subsequently judgment which I placed before Lordship, in that case, the early judgment was referred to. And by apex court, by referring to that, the judgment was rendered. And thereby, the observations or the decision of the Supreme Court in the later judgment will be binding. And the one cannot rely on the early judgment and to make a distinction with the subsequent judgment. I will have to give with liberty to your also two judgments. One, my lord, the judgment of this honorable court with a copy to my learned friend, and one on the sub silentio in the my lord per inquirium that you the judgment of the apex court on the sub silentio and per inquirium, where the high court's power and or not. On that, my lord, one copy to my other learned friend and one copy to the board. And also the intervener.
Yes, where is the order of intervening?
Hello?
That judgment on intervening,
No, that also. I think my learned friend, Mr. Sen, will like to say something. You want to say something?
On the other.
Which you can argue now.
Yes. 5 to 7 minutes. Some points which my learned senior had raised in this earlier matter. My lords, first of all, my lords, as far as the judgments are concerned, I won't take more than 10 minutes maximum, my lords, not more than. My lords, as far as the judgments are concerned, my learned senior's argument that out of context, one is looking at the CRR judgment, etc. My lords, that we are pointing out is this. The issue was, my lords, in fact, that's why I read out the tender conditions of all the three cases. Present case, CRR judgment, and the Titagar case, to show that in that case, the word use was single entity, and here it's bidder. That's the only difference. So the tender, technical tender for the purpose of bidding, word use there was single entity, and it interpreted to mean including its subsidiary. Here the word use is bidder. Bidder was not defined as such, but therefore it would mean a single entity. A bidder is also a single entity, my lords. And keeping that in mind, my lords, I had used the interpretations put forward in the CRR case. So, my lords, my first answer to that point would be in my respectful submission that it is not out of context. It is very much within context. And everything determines on the interpretation of the bid terms. And in that interpretation of the bid terms, my lords, it has been interpreted by the earlier courts. That's my first response. Then, my lords, may kindly see, as far as malice in law is concerned, my lords, I'm grateful to my learned senior that he's saying that he doesn't want to go into allegations below the belt. But my lords, once it's before this court, my lords, either one makes it or one doesn't make it. One can't say that I don't want to make it and then puts forward a statement, because then we will also have a lot to say about what it was and what it wasn't. There was a board decision which was taken. That board decision has not been doubted subsequently either by anyone in the organization or by the vigilance or anyone else. So, my lords, to say that a person was retiring just before the award of tender, my lords, is neither here nor there. And my lords, my respectful submission would be either it should have been pleaded in detail that he was collusively involved and he wanted to favor some party, or made him a party also, my lords. Or instead of that, my lords, when we say that Malafides has not been pleaded in detail, my lords, it would not be right to even take that submission into consideration. So, my lords, we are not answering that submission, and I respect my learned senior's argument that he doesn't want to hit below the belt and go into detail. But, my lords, even that few lines should not really be considered at all. This is my respectful submission. Then, my lords, may kindly see, he talks about malice in law, my lords. That's what we are arguing about. Malice in law depends on what interpretation you take of the tender guidelines. And, my lords, my argument here has been that interpretation is a matter. It's not that the court can't go into it, but there's a self-restraint to be exercised, a greater self-restraint in case of technical tenders and conditions, my lords, that need not be gone into. Then my lords may kindly see the other point which we have said and which they have accepted at para 57 at page 37 of our affidavit in opposition. We have specifically said, I won't take time, my lord, I'm just, my lord may make a marking of that, note of that para 57 of my affidavit in opposition, where I've said that MEIL is relying on DrillMech USA. Admittedly, my lords, DrillMech USA is not a banned entity. And it is one of the, it's an either or condition. So either you can be a crown, etc., whatever manufacturer, or a top drill drive, etc. manufacturer. It's an either or condition. My learned friend is today saying that it should be, if a person is supplying one part of the rig, he should be also equipped for the second part also. But my lord, that's a question of whether the tender conditions are proper or not. That's a condition, that's the issue, that whether the tender condition should have been cumulative, not alternative. That's a question on the tender conditions itself, which have not been challenged by them.
No, if I understood Mr. Chaudhary right,
Yes.
he's saying that for the first part,
Yes,
you must also have a manufacturing experience as well as supply experience.
yes,
For supply,
that is there.
for supply, you are borrowing it from Italy.
No,
Not
my
from
lord, I must clarify. I must. At page 101, if my lords may recall, that or is there, and there are two conditions. The upper one says for mast, crown, etc., both manufacturing and supply. For both, my lords, there is experience with DrillMech USA. Then comes or, and then comes the second condition. Second condition says top drive, etc., whatever that other part of the rig is. For that, again, both manufacturing and supply, that's where the Italy is being used. So, my lords, our submission is that, first of all, the whole issue of banning, etc., is irrelevant, because the technical criteria was, if you supply either of those conditions, that's fine. MEIL took care of the first condition with the help of DrillMech USA, which was not a banned entity. So there was nothing wrong in the technical capacity. That's our submission. So therefore, it's irrelevant whether it's banned, not banned, etc. That doesn't matter here. If my learned friend were to say no, ideally they should have experience in both, then my lord, that's a question of the tender conditions, which if he had challenged, I can understand. But if they have not been challenged, he's accepted it, he's participated in the tender. Then he
I don't think that is the
my lord,
argument.
I don't think if that's not the case, then
My lord, my learned friend is making his argument against his own pleading. Please come to my lord, page 11 of their affidavit, para 11.
my lords may.
Kindly see, my lord. They can't improve their case like this. Kindly see, my lord, para 11.
Yes, I'll read. Let the para 11 be read out.
They themselves say, my lords, para 11, while opening my argument, I have pointed out this para, that the deponent begs to state. Well, I have not argued anything new that my learned friend is again, otherwise there will be no end to it, my lord. I was only replying to him. And see para 11, that the deponent begs to state that respondent number 2, Megha Engineering and Infrastructure, who does not fulfill the bid evaluation criteria, rejection criteria on its own, had submitted its bid in the present tender on the technical strength of DrillMech USA and also DrillMech Italy SP, which are its 100% subsidiary. The bid was made by claiming experience and technology experience of DrillMech USA, who is a manufacturer of so-and-so. Respondent number 2 in their offer have also categorically clarified to carry out integration for supplementing the past supply experience against draw work, drive defense control, as well as relied upon the technical experience of the subsidiary DrillMech SP Italy.
Now, my lords, may I just make
So this is their case.
I'll just come. Now, my lords, may kindly turn to para 57. My lords, may see para 57 of the same affidavit. Actually, I didn't want to take time reading it out, but my lords, I think it's important, we must read that out. My lords, has that para 57, sorry. My lords, has para 57.
Yes.
My lords, it says that the ground raised in para D of the writ petition is neither tenable in law or in facts, and as such the same are liable to be rejected. the deponent says that the bid of the respondent number 2 was found technically acceptable based on the experience criteria of Drillmec Incorporated USA, which is not under any debarment, even though at the time the bidder would have had qualified experience, qualified based on the experience of Drillmec SPA Italy. It is therefore denied that respondent number 1 failed to ignore the bid of respondent number 2. So, my lords, I am saying very clearly and categorically that he has been found technically qualified on the basis of the experience of Drillmec USA. Para 57. And my lords may kindly see their response.
Same thing.
Yes. My lord, may I take my lords to the response? Page 892 of the reply on behalf of the petitioner to the affidavit in opposition.
Reply will come later. First, you'll have to demonstrate how you reconcile with para 11 and para.
Yes, now
57.
para 11. I'm sorry. I'm grateful, my lord. My lord may see para 11. Para 11, I'm pointing out what is a matter of fact. I'm not running away from that fact. My lord may see para 11. It says, my lord has that. The deponent begs to state that the respondent number 2, i.e. Megha Engineering and Infrastructure Limited, herein referred to as MEIL, who does not fulfill the bid evaluation bid criteria on its own, had submitted its bid in the present tender on the technical strength of Messrs. Drillmec Incorporated USA and also Messrs. Drillmec SPA Italy, which are its 100% subsidiary / sub-subsidiary. The bid was made by claiming the experience and technological expertise of Messrs. Drillmec Incorporated USA, who is a manufacturer of OEM of mast, substructure and count block assembly and also a rig package integrator. The respondent number 2 in their offer have categorically clarified to carry out integration of the rig packages by themselves in their own facility in India. For supplementing past supply experiences against drawworks, top drive and drilling control system, respondent number 2 has relied upon the technical experience of subsidiary Messrs. Drillmec SPA Italy. Well, this is a matter of fact which we are putting in para 11 to say. Yes. Yes. My lords, to say that if my lords may see that page 101 for first part, reliance on Drillmec USA, for second part, reliance on SPA Italy, which is what had happened. So my lords, I put that on record. And then I say at para 57 that for technical qualification, I have relied, because that's an either or, I rely on his Drillmec USA. Yes, both, my lords, and my lords, I'm glad my lords had asked that question, my lords. It says both. My lords may kindly see 101 again. I'm sorry. I'll just to, I won't. Yeah.
Just read that. It will be more
That
just read that. What you want to
my
show.
lord, I'll just read that. Sorry. I say that the A.1.2.1a of that A.1.1, it says that the bidder, manufacturer of mast, substructure, and crown block assembly, that is the first one, shall have an experience of minimum 10 years in manufacturing and supplying of mast, substructure, and crown block assembly under API specification. Both for supplying and for this thing, Drillmec USA is sufficient. So, my lord, that's our argument in this. Now, my lords, may I just their response to my para 57, because 57, I say I have technically qualified him on that basis. My lord, their argument is there is not that you should take both cumulative. My lord, and in fact, page 892, para 56, they say contents of para 56 to 63, because mine was para 57 of the affidavit. 55 to 57. Sorry, my lord. Page 55, page 891, para 55. Paras 55 to 57. I'll just read the last part at 892.
Yes.
Manoj, it says middle of that para, it says it is denying that the bid of respondent number 2 was found technically acceptable based on the experience criteria of DrillMech USA, which is not under any debarment, even though at the same time, the bidder would have qualified based on the experience of respondent number 3 being irrelevant and meritless. It is an admitted position that the respondent 2 by itself did not fulfill the pre-qualification criteria of BEC and BRC tender, and respondent number 2 relied on the experience and credentials of its foreign subsidiary companies, namely respondent number 3 and DrillMech USA. So, my lords, their argument is that no, it doesn't matter. They were themselves not qualified. So the subsidiary argument, that interpretation argument, on that basis they attack us. And they say, but for your other things, you relied on both DrillMech and this thing. And I have clarified that aspect, that it's an either or, it is not cumulative. That's all, my lord. That is the, as far as this is concerned. Now, my lords, may kindly come to the other point.
We have covered most of it.
Yes.
Yes.
But then I'll be.
Otherwise, they'll be going into it.
Guidelines, my lords. I won't. Just one more minute. 2 more minutes, my lord. My lords, 2017, the GFR rules of 2017 apply. The order of debarment, which was appealed against, that appellate order says that because it is from 6 months to 3 years, there is a window, there is a range which is provided. In the case of the GFR 2017, therefore, I feel that the punishment should be proportionate. Instead of 3 years, because it's not such a major infraction, it will be 1 year. They reduce it because there's a range in the GFR 2017. So therefore, they apply that criteria and they come to this conclusion. There is a reference to the 2021 guidelines saying even that provides for 3 years, because the argument was that it could be more. My lord, that was the thing. My lord, that is all. And my lords, one point, my lord, which I think my learned friend had said, and this is in the alternate, because as I said, debarment is not an issue. He says that the financial bid was open after the 2021 guidelines had come into existence. Now, my lords, admittedly, he admits to one point, that is in December, when the techno-commercial bid was open. At that time, the 2017 guidelines were applying. The person is found eligible as per that. Thereafter, my lords, when the financial bid is opened, he's saying now read back the 2021 guidelines to December, and because now as per the 2021 guideline, the December one is not applicable. The person would not be eligible. The techno-commercial bid was also not eligible. This would be what, my lords? You are putting the guideline retrospectively, which is not what the guidelines intended, and it is not the wording of the guideline also. Yes, at the techno-commercial, at the financial bid stage, by that stage, if the technical commercial was all right, if under that regime I'm suitable, when the financial bid is being opened, it will be as per that. It will otherwise be reading back the 2021 guidelines retrospectively to annul a decision which has been taken place earlier under the old guidelines. But I won't take more time.
But I just need to clarify one point of that. If you lordship to kindly come to page 344 of the petition, my lord.
Just tell me what is it?
My lord, under the 17 guideline of policy of oil, the banning has to be for 3 years. Now it is their own case that it is under 17 guideline only they have done it. Clause 4.3, it clearly, please have a look, my lord, 1 minute.
Just tell me because
Yes.
this is not jumbled up.
Period of banning shall be 3 years from the date of issuance of the order. This is 4.3. Regarding holiday, my lord, it is 5.3 at 351. Regarding holiday, the clause is 5.3 at page 351. It speaks of 6 months to 2 years.
What it is, clause number
5.3,
page.
page 351. And duration of holiday is 6 months to 2 years. Now it is their own case. The debarment has been reduced to 1 year. So there is no provision in 17 policy guideline of reduction.
Debarment is 4.3.
Yes. Debarment is 4.3, banning or debarment is
At
3
page-
years.
Page,
Page 344. And my lord, one more important. 5.4 is effect of holiday. Now, my learned friend, as a employer, he is trying to say that something, there's a difference between holiday and banning. Well, the effect is same. Can you see? If an agency is put on holiday list, it shall not be considered for any tender. So how the distinction is, making any sense, my lord? On the contrary, it speaks of the opposite thing. It clearly says, if an agency is put on holiday list, it shall not be. Therefore, the issue is, even now they are not placing, my lord, that final order of appeal. That is to their detriment. They are taking a chance. Now that will reveal they have which policy they have applied to bring, bring down the order of debarment from 3 years to 1 year.
No, that is not by them. It is by the IEM,
No, not IEM.
the appellate authority.
Appellate authority, their own creation. Is there all India's appellate authority? Their own order.
But
So,
it's
my lord,
otherwise-
still now they are not bringing on record. That's a very interesting part, my lord. So, my lord, therefore, to say that there is a difference between banning and holiday is absolutely not correct.
So, Malak, this is now, I don't want to go on and on, but it's contrary to the pleadings. Malak, in the pleadings, it's very clear. We have talked about holiday list, which has not been denied by them. That is number one. And Malak, we are going, the order has been passed by.
So it's okay, we have to stop somewhere.
Yes, GFR 2017 is what applies, my lord, and that an integrity pact, because it was a 2015 incident. Even prior to 2017. So GFR 2017 and integrity pact, which was there at that. And well, that's 6 to 3 years. Everywhere it says there's a range, and they reduce the range.
No, for that, Mr. Sen.
Yes.
There's nothing on record to show that when it comes to integrity pact,
Yes,
then it has to be treated differently than what is there in that 2017 GFR.
absolutely. I'm only saying that the reduction, whether the appellate authority had the power to reduce the period.
No,
of-
that is, you see, that is what is required to be responded to,
Yes,
because Mr. Chaudhary's case is now, he said it earlier also,
Yeah.
that once it is a holiday, there is a leeway between 6 months to 2 years.
yes,
But when it is a debarment or a
yes,
banning,
yes,
then it is a 3-year prescription.
Yeah.
yes. Absolutely.
Ah.
That's why, my lord, I was pointing out the pleadings, and I'll put that on in a response submission. In the pleadings, we have clearly said holiday list, to which there has been no specific denial on that aspect. Now, this is being argued today. That's a separate issue.
No, because that is all, that is based on document,
Because,
that is document based.
sorry.
That is a document based.
Yes, document, I'm not denying that. That's why document based is, if we see the appellate authority order, GFR, which has a range, and therefore it reduces the range. Saying that as per the financial rules, this is the range, which is that don't give it so much thing, reduce it to 1 year. So it's 6 months to 3 years, they reduce it to 1 year. That is permissible. And it was under the integrity pact, that was the initial thing. But we'll put it in our written submission with specific reference to the plea.
Whether this judgment, this is a lengthy judgment, if you'll also permit me, I will mark the alien person with the copy to other side also. Because it
Regarding the other case? Today it cannot be concluded, but question is, I think,
I'm ready to argue on it, no problem.
day after tomorrow.
No, then you better start it.
Ah.
Today, if you want to continue. Otherwise, I'll be posting those matters after view.
Mhm.
Now, no further new matters will be heard. I really don't have time.
You also want me to start?
Yes, if you want, if you intend to spill it off to day after tomorrow, then you start today.
I have no problem.
Just a minute, Dr. Goswami was here in an earlier matter. Yes. Dr. Goswami, who's for the petitioner in your case? Who is the petitioner in your case?
possible কিমান time লাগবে? কিমান time? 1 hour? এক ঘন্টা? Item number 4. Sir, মুখ যেটা 15 মিনিট যেমন হয়ে যাবে।
Please come here.
15 দিন না।
My lord, MK Soduri was there for the petitioner.
Okay, is anybody there for him? Item number?
Lordships, can I make one submission, my lord? ওই পাতাটা কি লোক না?
Just a moment.
My lord, what I was
there's another
trying to,
matter.
yes, my, that's what I'm saying, my lord, hardly 15-20 minutes is left. If your lordship takes up the other matter, my lord, but if my learned friend can conclude it in 1.5 hours, I'll just take maximum half an hour. So day after tomorrow, second half, my lord, it can be closed, my.
We'll finish it, my lord.
No, there's a election matter fixed on the day.
Oh,
It spills over to after view.
oh,
I'll not be able to give time. There's an election matter and it's a highly contested matter.
Even if I start also, then also it will go to Thursday.
So then I'll post it after view. I'll not be able to do it. And I don't want to burden myself with a hearing and then spill over the matter. You choose a date after view. Both of you can agree to a date.
20th April.
my lord, we reopen on 19th, my lord.
Yes.
21st.
My lord, next 30, is it possible anyway, my lord? 30, Thursday.
No, because I'll have to spill over. If it spills over, then I have to avoid.
27 27.
Anyway, this matter is concluded. Other matter is left.
This is concluded.
27.
20. 20.
We'll fix
You're
it.
reopening day first.
Secretary will come.
I have no problem.
20, my lord.
20. Okay. Let the secretary come. I'll pass an order. You may leave. But I'll pass orders.
20.
We'll celebrate, yes. Don't worry. I'll offer you.
You may leave. I'll pass orders.
20th April.
20.
You may leave. I'll pass orders because my
Yes.
secretary is not there.
Yes.
21st.
Deep.
21st is the election day.
Yes, your lordship.
Yes.
I'm appearing for the petitioner in item number 4, my lord. This matter may kindly be adjourned for today.
Mr. Goswami, Dr. Goswami has been sitting for the entire day. He's been sitting for the entire day.
Would have been disposed of.
My lord,
Then
Mr.
it is filed.
the senior advocate is on his legs in another court.
Yes, Dr. Goswami.
My lord, you can fix it. Any other day, my lord.
Monday.
Monday,
Where-
Monday, my lord. My lord, Wednesday, 29th. Wednesday.
Okay. On the. Just a moment. All sides are duly represented. On the prayer made by Ms. N. Ahmed, the counsel for the petitioner. Matter stands adjourned today. If they agree to by all sides, is on 29/3/2023. Yes. No, madam. Third solution, argument concluded, judgment reserved. Item 2. 24. Item 3. Is the argument in the connected matter being WPC 4549 of 2020 is concluded, or this matter is detached and will be heard separately. List for hearing on 20/4/2023. This is matter of hearing. Okay. Yes.
6 to 9.
Item 5.
The review petition for the respondents.
This is elementary education. This is elementary education.
Review petition, no?
Review.
Lordship, in this matter, Lordship, Mr. N.J. Khatanian is supposed to appear, Lordship. I'm appearing for the department, my Lord. My Lord, today he had some medical emergency. He could not make it to the court. My Lord, for today, my Lord may just for today, my Lord may pass over. In the meantime, my Lord, he was coming, Lordship, but then because of medical emergency. Item 6, Lord. Mr. N.J. Khatanian.
This goes after Bihu. Will not be able to take up in these days.
Otherwise, the review petition is non-maintainable, my Lord. 3 writ petitions were disposed of by a common judgment, my Lord. They have filed preferred review against one judgment, one writ petition. The other writ petitions, they have not preferred review. So this review petition itself is not maintainable, my Lord. Otherwise. So, take up a
But
call.
still, for hearing, I will not be able to devote time.
It will take much time, my Lord. It will not take much time. On the next days, Lordship tries to dispose of this writ petition, review petition. my Lord.
Yes, sir. Others? Okay, 31st March then,
My Lord.
My Lord.
on the prayer made by Mr. A. Pugan, Council for the Elementary Education Department, Barrister George today. List of 31C.
Oblige, my Lord.
Deeply obliged.
11 to 20.
Well, today, my lord, was a big hearing, another hearing, maybe not big. My lord will give a,
You're right.
my lord will have a,
In fact, this is the only submission in the entire day which has made me happy.
no, my lord, we have to say, my lord has been totally applying a mind for that matter. Again, coming out with it, and the time is also not.
You suggest a date?
My lord, convenient to your lordship, my lord. Other than 30 and 31st, any date, your lordship.
Next week, hearing.
Any date convenient, your lordship.
You suggest because I am the
My lord, let it be next Tuesday then. We'll take a try. Or my lord can take it on a motion day. I have no problem, madam. 2 p.m.
Oh, there's a division bench on the day,
Oh, then Monday, 2 PM, my lord, if not, Monday,
Monday,
Monday, 2 PM. We'll try to be short as possible. my lord.
31st. 3-0, my proposal is Thursday. 3-0, 30 March.
My lord, 30 and 31st, I may
Oh,
have some
acha.
trouble. 29. Okay.
29? Okay, 29 then.
29.
All sides are duly represented.
My lord, if required, my lord can fix it at 2, my lord, if. My lord
No,
can.
I'm not fixing it. Just in the morning, you remind me.
I'll
to
make
take it up at 2.
Much obliged.
Due to positive time matter could not be taken up today. This is the matter again on 29, 3/2022, 23.